Constitutional treason. Cannabis was never illegal. Legal doctrine of recognition, not legalization. By Professor Isaiah Alleman. Word count 20,123 plus. Pages 54. Constitutional treason. Federal government's prohibition and legalization of cannabis. C. 2025. Isaiah Delmar Alleman. All rights reserved. No part of this book may be reproduced, stored in a retrieval system, or transmitted in any form or by any means electronic, mechanical, photocopy, recording, scanning, or any other digital or analog types or forms of duplication, in full or fragment, or used in any manner without the purchase proof from the author of prior written descriptive permission, that shall be signed with one true physical biometric doublet self-authenticating, plastic aka molded print, or similar readily visible signature by the true copyright owner, except for the use of brief quotations in a book review, article, and interviews. Additionally, any unauthorized distribution, sharing, or sale of this book, whether in physical or digital form, is strictly prohibited and may result in legal action. The author reserves all rights to this book, including, but not limited to, the right to revise, edit, and adapt the content in any way deemed necessary. Any infringement on these rights will be pursued to the fullest extent of the law. If you have any questions or concerns regarding the use of this book, please contact the author directly. Thank you for respecting the author's intellectual property. Book designed by Isaiah Delmar Alleman. ISBN, physical copy. ISBN, digital copy. Table of contents. Chapter 1, Constitutional Foundations of Cannabis, Natural Law, Enumerated Rights, and Original Intent of the Framers. Analysis of cannabis within the context of United States Constitution, focusing on natural law, 9th and 10th Amendments, and irreconcilability of federal prohibition with original constitutional intent. Chapter 2, Fraudulent Origin of Prohibition, Racism, Corporate Collusion, and Weaponization of Language, Socio-Political and Economic Motives Behind Cannabis Prohibition, emphasizing racialized rhetoric, industrial lobbying, and linguistic deception embodied in foreign, therefore uncommon terms marijuana. Chapter 3, Judicial Nullification, Doctrine of Void for Vagueness, Case Law Against Cannabis Prohibition, Judicial Precedents and Doctrines, Marbury v. Madison, Supremacy Clause, Statutory Construction, which render cannabis prohibition, therefore, legalization legally untenable and constitutionally void. Chapter 4, Ethical Philosophy, Religious Liberty, and the Right to Cognitive Sovereignty, Philosophical and Theological Exploration of the Human Right to Self-Governance of Thought and Consciousness, with cannabis as a sacred plant interwoven into spiritual, cultural, and cognitive autonomy. Chapter 5, Commerce, Agriculture, and the War on the Poor, Economic Destruction Wrought by Cannabis Criminalization, Economic Autopsy of Prohibitionist Model, demonstrating its role in disenfranchising farmers, decimating indigenous economies, and fostering corporate monopolies over natural medicine and agrarian sovereignty.
Chapter 6, Sistema endocannabinoide y la soberanía lingüística, perspectivas jurídicas en el mundo hispano. Un capítulo jurídicamente sofisticado y lingüísticamente preciso, redactado íntegramente en español, que examina el tratamiento legal, histórico y cultural del cannabis en el mundo hispanohablante. Se analizan las definiciones legales en los códigos civiles y penales, las políticas públicas comparadas, y la importancia de preservar la terminología correcta como acto de soberanía jurídica y resistencia lingüística frente a la propaganda colonial y anglosajona.
Linguistic legal considerations entirely in Spanish, detailing juridical, cultural treatment of cannabis in the Spanish-speaking world, with emphasis on terminology, sovereignty, and international law. Chapter 7, Medical Apartheid, the governmental suppression of therapeutic cannabis, and the right to heal. Medical literature, government patents, deliberate suppression of cannabis as therapeutic, right to informed consent and bodily autonomy. Chapter 8, Cannabis, the environment, ecological restoration, bioremediation, the green future of law. Cannabis's unparalleled environmental applications, legal restructuring needed to embrace its regenerative potential for soil, air, water, and climate stabilization. Chapter 9, Prison Industrial Complex, Economics of Incarceration. Cannabis, a tool of modern slavery. How cannabis prohibition has served to entrench racial disparities, expand the carceral state, and generate profit from the commodification of human confinement. Chapter 10, Linguicide and Lexical Fraud, the capitalization of cannabis and the criminalization of truth, strategic linguistic manipulation, used to subvert public understanding, and legal analysis of how mislabeling cannabis as marijuana constitutes felony perjury and intentional semantic warfare. Chapter 11: Endocannabinoid System, Historical Foundations, Nomenclature, and Legal Implications. Endocannabinoid stem, its naming after cannabis, and constitutional violations inherent in denying the plant's medical legitimacy, while simultaneously acknowledging its biochemical centrality to human health. Constitutional treason, federal government's unlawful prohibition and legalization of cannabis. Chapter 1. Never lawfully illegal. Cannabis should not be legalized because it was never legally prohibited in a constitutionally valid manner, is the only honest and honorable legal position. This argument hinges on fundamental principles of constitutional law, statutory interpretation, and the doctrine of ultra vires, beyond legal authority. Why is cannabis prohibition was unlawful from the start and why its current legalization is itself an unlawful act. 1. Constitutional principles and the rule of law. The foundational principle of the U.S. legal system is that laws must adhere to the Constitution. If a law is unconstitutional, it is void ab initio from the beginning. This was established in Marbury v. Madison, 5 U.S., 1 Cranch, 137, 1803, where the Supreme Court declared, a law repugnant to the Constitution is void. Cannabis prohibition was unconstitutional at its inception, then its enforcement was unlawful, and any subsequent legalization is an illegal act because it presupposes that the prohibition was ever valid. Limited powers of the federal government. Under the 10th Amendment, powers not explicitly granted to the federal government are reserved to the states or the people. The federal government was never granted the power to regulate substances, such as cannabis, under any valid constitutional framework. Commerce Clause, Article 1, Section 8, Clause 3, has been used as the justification for federal drug laws. However, in United States v. Lopez, 514 U.S. 549, 1995, the Supreme Court ruled that Congress overstepped its authority under the Commerce Clause when it tried to criminalize gun possession in school zones. This ruling establishes that there are limits to how broadly Congress can apply the Commerce Clause. Applying Lopez to cannabis prohibition, Congress had no legitimate constitutional authority to prohibit cannabis nationwide under the Commerce Clause. The absence of a constitutional amendment. The federal prohibition of alcohol required the passage of the 18th Amendment, and its repeal required the 21st Amendment. No such amendment was ever passed to authorize cannabis prohibition. Instead, prohibition was enforced through statutes, such as the Marijuana Tax Act of 1937. However, the Supreme Court in United States v. Constantine, 296 U.S. 287, 1935, ruled that Congress cannot use tax laws as a means of enforcing criminal prohibitions that would otherwise be unconstitutional. The Marijuana Tax Act was not truly a tax, but a de facto prohibition, making it unconstitutional under Constantine. Thus, the 1937 marijuana prohibition of cannabis was willfully and intentionally illegitimate. 2. Federal Prohibition, Controlled Substances Act, CSA. In 1970, the Controlled Substances Act, CSA categorized cannabis as a Schedule I drug, meaning it was deemed to have no accepted medical use, and a high potential for abuse. However, a violation of due process under the 5th and 14th Amendments requires that laws be based on rational, factual determinations. Any and all marijuana prohibition cannabis violates due process, because the Schaefer Commission 1972, appointed by President Nixon, concluded that cannabis should not be criminalized. Scientific evidence overwhelmingly contradicts the CSA's classification of cannabis as a Schedule I substance. Courts have ruled that arbitrary laws violate due process. Romer v. Evans, 517, U.S. 620, 1996, established that laws must have a legitimate government interest and not be based on animus or political motivation. But the governments have never had sincere nor honest nor honorable interests with cannabis, only evil actions with its exclusive possession and open displays of guilty mind because of government's behaviors. Thus, the CSA's marijuana classification of cannabis was arbitrary, unconstitutional, repugnant, and void. Ab initio, violation of the Equal Protection Clause. Enforcement of cannabis via marijuana prohibition disproportionately targeted racial minorities and the poor, violating the Equal Protection Clause of the 14th Amendment. Yickwo v. Hopkins, 118 U.S. 356, 1886, ruled that even neutral laws that are enforced discriminatorily are unconstitutional. McCleskey v. Kemp, 481 U.S. 279, 1987, acknowledged racial disparities in criminal enforcement, but required clear proof of discriminatory intent. The proof is historically and currently evident. The Nixon administration's own aides admitted that cannabis prohibition was designed to target Black Americans and anti-war activists. He was one among many who admitted guilt openly to the public. Because cannabis laws were enforced discriminatorily, they were unconstitutional. 3. Principle of void laws and why legalization is improper and illegal. If a law was unconstitutional from the beginning, then 1. It was never legally in force. 2. All actions taken under it were unlawful. 3. It does not need to be prohibited or legalized, it simply needs to be repealed, at least recognized as null void. Cannabis prohibition and legalization is recognized as null and void, wholeheartedly irrelevant to free people. This principle is reinforced in Norton v. Shelby County, 118 U.S. 425, 1886. An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is, in legal contemplation, as inoperative as though it had never been passed. Ex parte Siebold, 100 U.S. 371, 1879. Where the court held that an unconstitutional statute imposes no duties, and does not act as a rule of conduct. Since cannabis prohibition was unconstitutional, the proper legal remedy is not legalization, but recognition of its illegality and reaffirming the people's popular sovereignty and reserved rights. 4. Unlawfulness of legalization. By legalizing cannabis, legislatures and courts imply that its prohibition was ever valid. This is unconstitutional because prohibition was void from the start. Laws that are void ab initio cannot be repealed. They never had legal effect. Prohibition is, was, will always be legally poisonous fruit. Legalization, therefore, is also legally poisonous fruit. The correct course of action is for courts to declare cannabis prohibition unconstitutional, not to enact new fraudulent prohibitive legalization statutes of continued injury and extortion. Legal remedy: nullification, not legalization. The Supreme Court should recognize that cannabis prohibition violated constitutional principles as indicated, and the Declaration of Independence and Constitution were drafted on cannabis paper. All convictions under cannabis laws were wrongful. All licenses and fees are harmful. The government shall compensate those harmed by the over 165 years of unlawful enforcement. This principle aligns with Marbury v. Madison and Norton v. Shelby County, reinforcing that unconstitutional laws are void and cannot be fixed by new legislation. Legalization is legally impossible. Cannabis does not need to be prohibitively legalized in any way, and shouldn't be because it was never lawfully illegal. Instead, all laws against it must be recognized as void. Those harmed by its prohibition must be provided legal redress and substantial compensation. Chapter 2. Poison fruit. Focusing on Article 4, Section 2, Paragraph 1 of the U.S. Constitution, and the Supreme Court rulings in Murdoch v. Pennsylvania and Shuttlesworth v. City of Birmingham, Alabama, in the context of reparations, particularly with respect to unlawful prohibition and criminalization of cannabis, its disproportionate impact on certain populations. Case frame for reparations using foundational legal principles and precedent. 1. Article 4, Section 2, Clause 1. The Privileges and Immunities Clause. This clause was designed to protect the fundamental rights of citizens as they travel between or reside in different states. It guarantees that a citizen cannot be discriminated against based on their state of origin, and ensures equal access to the rights and protections afforded by federal and state law. However, when states criminalized cannabis, they created a system where certain citizens, based largely on geography, race, or political targeting, were denied the full privileges and immunities due to every American. Specifically, individuals in some states faced lifelong disenfranchisement, loss of property, denial of employment, and imprisonment for acts that are now considered legal in other states. This constitutes an unconstitutional abridgment of equal rights and privileges across state lines. Under Sines v. Roe, 526 U.S. 489, 1999. The court reaffirmed the principle that fundamental rights cannot be denied based on one's state of residence. Thus, the disparate and arbitrary enforcement of cannabis laws not only violated due process, but directly contravened Article 4, Section 2 of the Constitution. These violations laid the groundwork for claims of restitution and reparations. 2. Murdoch v. Pennsylvania, 319 U.S. 105, 1943. In Murdoch, the Supreme Court held that requiring a license fee for religious literature distribution was an unconstitutional tax on a First Amendment right. This decision underscores a foundational legal doctrine: no government may lawfully license or tax a fundamental right. Applied to cannabis, cannabis use, cultivation, and possession fall under privacy, liberty, medical autonomy, and economic self-determination, all easily and appropriately arguable fundamental rights. Any taxation, licensure, or prohibition of such fundamental liberty is therefore a violation of Murdoch. Cannabis prohibition amounted to charging people with crimes, or imposing fees and punishment for engaging in constitutionally protected behavior, especially when used for religious or medical purposes. Thus, Every conviction, fine, and incarceration under these unlawful licenses and taxes constitutes not just injustice, but state-sanctioned theft, for which restitution is legally required. 3. Shuttlesworth v. City of Birmingham, 394 U.S. 147 1969. In Shuttlesworth, the court overturned the conviction of a civil rights activist who had not obtained a permit to parade. The justices ruled that the ordinance giving arbitrary discretion to city officials to grant or deny permits was unconstitutional, particularly when used to suppress constitutionally protected conduct. Cannabis laws were enforced in the exact same unconstitutional manner. Discretionary enforcement targeted specific racial, political, and religious groups. Licensing boards, police, and courts exercised unrestrained power to deny rights, enforce punishments, and confiscate property. The intent and effect of these laws mirrored the Jim Crow mechanism struck down in Shuttlesworth to suppress the autonomy of Black Americans, indigenous people, Latinos, and counterculture political dissenters. The discriminatory discretion embedded in cannabis enforcement renders its fruits not only unlawful, but poison tainted beyond the possibility of retroactive justification. 4. Legal principle. Fruit of the poisonous tree, derived from Silverthorne Lumber Company v. United States, 251, U.S. 385, 1920, and expanded in Wong Sun v. United States, 371 U.S. 471, 1963. This principle holds that if the source of a government action, law, arrest, charge, conviction, is unlawful, then all its consequences, imprisonment, fines, forfeitures, stigmas, are likewise invalid. This includes felony records, loss of voting rights, denial of employment, housing and education, psychological and economic trauma. Cannabis convictions are fruits of poisonous legislative trees. Their enforcement under unconstitutional laws requires not only expungement, but reparative justice for the injuries caused. 5. Reparations, legal mandate, not political charity. The U.S. legal system provides multiple mechanisms for reparations when state actors commit unconstitutional harms. Tort claims, victims of unlawful government actions, are entitled to damages. Takings Clause, Fifth Amendment, prohibitions and asset forfeitures under unlawful cannabis laws constitute uncompensated takings. Bivens actions. Bivens v. 6 unknown named agents, 403, U.S. 388, 1971. Victims of unconstitutional federal conduct may sue for damages. Class actions. Large-scale injury caused by government policy allows for systemic restitution. Historical precedents. Korematsu v. United States, 323 U.S. 214, 1944. Led to later reparations for Japanese internment. The Civil Liberties Act of 1988 paid $20,000 to each Japanese American internee, acknowledging that racially motivated laws are inherently unconstitutional and require restitution. Cannabis prohibition. Racially motivated, lacking legal foundation, and enforced with discriminatory discretion qualifies under the same logic. 6. Conclusion. Poisoned roots demand cleansing restoration. The illegality of cannabis prohibition is not only a question of faulty policy, it is a fundamental breach of constitutional guarantees. Murdoch affirms that no fee or license may condition a right. Shuttlesworth declares that arbitrary discretion over rights is unconstitutional. The Privileges and Immunities Clause forbids disparate treatment across states, and the principle of fruit of the poisonous tree demands that all downstream harm be nullified. Therefore, reparations are not optional, they are the mandatory legal consequence of a century-long regime of unlawful policy, systemic discrimination, and constitutional betrayal. What was unlawfully taken must be lawfully restored with interest. Chapter 3. Constitutional Nullity of Cannabis Prohibition, Doctrine of Illegality and the Mandate of Redress. 1. Doctrine of Legality, a foundational precept of American jurisprudence, demands that no person be punished under a law unless the law is valid, constitutional, and clear. The American experiment, as memorialized in its founding documents, is undergirded by the supremacy of the Constitution and the constraints it imposes on the coercive powers of the state. Cannabis prohibition, from its inception, was a deviation from these principles, a doctrinal nullity, whose enforcement gave rise to cascading constitutional injuries. In this chapter, we examine the jurisprudential framework that reveals cannabis prohibition as not only unconstitutional in substance, but void ab initio, thus invoking the legal imperative of redress and restitution. 2. Void for vagueness doctrine. Prohibition of cannabis fails under the void for vagueness doctrine, first articulated in Connolly v. General Construction Company, 269 U.S. 385, 1926, and expanded in Papachristow v. City of Jacksonville, 405 U.S. 156, 1972. A penal statute must define the criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited and must not encourage arbitrary or discriminatory enforcement. The alien term marijuana, used in early statutory schemes such as the Marijuana Tax Act of 1937 and the Controlled Substances Act of 1970, lacked botanical, pharmacological, and scientific precision. Many inconsistencies in federal and state classifications, shifting scheduling, and culturally biased interpretations rendered enforcement arbitrary. Selective prosecution of marginalized communities exemplifies the very kind of vagueness-induced discrimination condemned by the court in Papachristou. A law that criminalizes conduct without objective clarity is not a law at all. 3. Substantive due process and the right to bodily autonomy. 14th Amendment Due Process Clause protects those rights so fundamental to the concept of ordered liberty that neither liberty nor justice would exist if they were sacrificed. As held in Griswold v. Connecticut, 381 U.S. 479 1965, Roe v. Wade, 410 U.S. 113, 1973, and later in Lawrence v. Texas, 539 U.S. 558, 2003, bodily autonomy, privacy, and personal liberty form a constitutional substratum immune to unjustified government interference. Criminalization of cannabis, particularly for personal, medical, or spiritual use, violates the substantive liberty interests enshrined in these precedents. Where no compelling governmental interest exists, and less restrictive means are available, prohibition is impermissible. The government's reliance on discredited studies and racially charged propaganda does not meet strict scrutiny demanded when fundamental rights are curtailed. 4. Equal protection and animus-based legislation. Equal protection clause prohibits laws motivated by irrational or discriminatory animus. In Romer v. Evans, 517, U.S. 620 1996, the court invalidated a statute based solely on moral disapproval and animus. Legislative history of cannabis prohibition is replete with racially discriminatory intent, as evidenced by statements from policymakers, such as Harry Anslinger, who conflated cannabis use with minority populations to generate public panic. In Yikwo v. Hopkins, 118 U.S. 356, 1886, the court held that facially neutral laws enforced in a discriminatory manner are unconstitutional. Racially disparate enforcement of cannabis laws, documented exhaustively in both state and federal jurisdictions, renders the entire regime constitutionally infirm. 5. First Amendment: religious and expressive use. In Sherbert v. Verner, 374 U.S. 398 1963, and reaffirmed in Wisconsin v. Yoder, 406 U.S. 205 1972, the Supreme Court established that laws burdening sincere religious practice must be justified by a compelling interest and must be narrowly tailored. Cannabis has been a sacrament in religious traditions including Rastafarianism, Native American ceremonies, and various new religious movements. Under Employment Division v. Smith, 494 U.S. 872, 1990, even neutral laws may violate the free exercise clause when exceptions are granted to secular, but not religious uses. Arbitrary denial of religious exemptions for cannabis use, while granting broad secular allowances in medical and recreational contexts, contravenes the First Amendment. 6. Commerce Clause and Federalism Problem. In United States v. Lopez, 514 U.S. 549, 1995, the court reigned in federal overreach under the Commerce Clause. In Gonzalez v. Reich, 545 U.S. 1, 2005, the court upheld federal authority to regulate intrastate medical cannabis. However, the Reich decision was fractured and controversial, with Justice O'Connor's dissent emphasizing states as laboratories of democracy. 10th Amendment reserves powers not delegated to the federal government. Aggressive federal criminalization of non-commercial, intrastate cannabis use violates federalism and state sovereignty, especially when states expressly legalize such conduct. The resulting dual sovereignty conflict undermines the uniform rule of law. 7. Property rights and civil forfeiture. Takings without just compensation. Fifth Amendment's takings clause forbids the government from seizing property without just compensation. Civil asset forfeiture laws related to cannabis enforcement enabled the state to seize homes, cash, and vehicles from individuals never convicted of a crime. In Austin v. United States, 509 U.S. 602, 1993, the court recognized that civil forfeitures implicate Eighth Amendment protections against excessive fines and are subject to constitutional scrutiny. Cannabis enforcement under civil forfeiture regimes resulted in de facto theft, violating not only the Fifth and Eighth Amendments, but also principles of procedural due process set forth in Matthews v. Eldridge, 424 U.S. 319, 1976. 8. Retrospective injustice and ex post facto clause. Ex post facto clause prohibits retroactive criminal penalties. Evolving legal status of cannabis from Schedule I to decriminalization and legalization displays the retrospective injustice imposed on individuals prosecuted under now invalid or overturned statutes. As Justice Stevens noted in United States v. Booker, 543, U.S. 220, 2005, punishment regimes must be consistent with evolving standards of justice. 9. Mandate of redress. Constitutional infirmities of cannabis prohibition are not isolated, they are systemic and compound. From vague and arbitrary enforcement to the denial of fundamental rights, the regime constitutes an irredeemable nullity under constitutional jurisprudence. As Brown v. Board of Education, 347 U.S. 483, 1954, marked the end of de jure segregation, so too must the full repudiation of cannabis prohibition come with not only recognition, but restitution. Redress is not a political aspiration, it is a constitutional necessity. Doctrine of legality cannot tolerate continued punishment, disenfranchisement, and impoverishment of individuals under a regime that was never lawful to begin with. Jurisprudential command is clear. All that was taken must be restored. Chapter 4. Equal cannabis freedom for all, without exception. 1. Legal mandate of equal protection in substance and scope. The bedrock promise of American constitutionalism is equality before the law. Where liberties are recognized, they must be universally distributed. Where rights are restored, they must be equitably restored. Any selective dispensation of liberty violates the Equal Protection Clause of the 14th Amendment and entrenches a hierarchy of personhood antithetical to the Republican form of government guaranteed under Article 4, Section 4 of the U.S. Constitution. The modern relegalization of cannabis, while politically progressive in appearance, is jurisprudentially regressive when implemented through fragmented state-by-state exceptions, privilege-based licensing regimes, and retroactive exclusions. Equal cannabis freedom is a constitutional imperative, not a legislative option, whose denial constitutes a continuing violation of substantive due process. Equal protection, the 13th Amendment's prohibition on badges and incidents of slavery, and the First Amendment rights to expressive and religious autonomy. The rule of law demands uniform liberty, not conditional clemency. Justice, if it is to be legitimate, must be both blind and indivisible. 2. Equal protection and the prohibition of tiered liberty. The Equal Protection Clause, as first robustly applied in Yick v. Hopkins, 118 U.S. 356, 1886, forbids laws that confer privileges on a favored class while denying the same to others similarly situated. Cannabis licensing systems that favor affluent, white, or politically connected entities while excluding those with prior convictions are limited capital violate this foundational command. In Skinner v. Oklahoma, 316 U.S. 535, 1942, the court held that when legislation touches upon fundamental rights, distinctions among classes must survive strict scrutiny. Cannabis prohibition regimes, followed by exclusive legalization models, amount to a double deprivation. First, the unlawful criminalization of a substance, and second, the monopolized reallocation of its commercial benefits. No state may criminalize a right, and then license its restoration to a select few. 3. Privileges, immunities, and the Reconstruction Amendments. The Privileges or Immunities Clause of the 14th Amendment, though weakened in the slaughterhouse cases, 83 U.S. 36, 1873, has regained analytical vitality through contemporary scholarship and jurisprudence that re-examines its original meaning. The right to access and cultivate natural medicine for one's own health, livelihood, or spiritual purpose constitutes a privilege of national citizenship, one that cannot be abridged on the basis of geography, ancestry, or past prosecution. The Reconstruction Amendments, particularly the 13th and 14th, require affirmative dismantling of laws and institutions that perpetuate economic and racial subordination. As held in Jones v. Alfred H. Mayer Company, 392 U.S. 409, 1968, the 13th Amendment empowers Congress to eliminate the badges and incidents of slavery. The criminalization and exclusion of African Americans, Latinos, indigenous peoples, and the poor from both cannabis freedom and industry constitutes such a badge, warranting immediate federal remedy. 4. First Amendment: religious, expressive, and associational autonomy, liberty of conscience and spiritual practice, protected by the First Amendment, cannot be conditioned upon state-issued permits or profit-based frameworks. As held in West Virginia State Board of Education v. Barnett, 319, U.S. 624, 1943, and Church of the Lukumi Babalu, IV Hialeah, 508 U.S. 520 1993, the state may not suppress religious conduct simply because it deviates from majority norms. Cannabis, as sacrament and symbol, cannot be regulated out of the hands of the sincere while granted to the privileged. Moreover, expressive conduct such as the open cultivation, use, or distribution of cannabis as a political statement or lifestyle receives constitutional protection under Texas v. Johnson, 491 U.S. 397, 1989. The creation of regimes where only certain uses or speakers are allowed commercial access constitutes viewpoint discrimination, impermissible under core First Amendment doctrine. 5. Selective enforcement, racial disparities, and the constitutional prohibition of arbitrary justice. The selective enforcement of cannabis laws has been empirically proven to fall with disproportionate severity upon Black and Brown communities, as the Supreme Court held in Wren v. United States, 517, U.S. 806, 1996. Pretextual stops may be lawful under the Fourth Amendment, but equal protection challenges remain viable where selective prosecution is racially motivated. The racialized enforcement of cannabis prohibition is thus not only a policy failure, but a constitutional breach. When states legalize cannabis, but fail to automatically expunge past convictions, or erect barriers to participation for the previously incarcerated, they convert prior constitutional injuries into enduring structural inequalities. Such systems violate Batson v. Kentucky, 476 U.S. 79, 1986, and McCleskey v. Kemp, 481 U.S. 279, 1987, by transforming statistical discrimination into legal structure. 6. The Dormant Commerce Clause and the illegality of localized monopoly. The Dormant Commerce Clause prohibits states from engaging in economic protectionism that impedes the free flow of lawful commerce across state lines. As in Granholm v. Heald, 544 U.S. 460, 2005, where the court struck down discriminatory alcohol laws, so too should cannabis regulations that prohibit out-of-state producers or favor local enterprises. Equal cannabis freedom demands national parity, not provincial fiefdoms. Any legalization framework that functions as an economic cartel violates the Sherman Antitrust Act and the spirit of the Commerce Clause. Federal courts retain equitable power to enjoin such schemes when they offend the constitutional promise of open and equal markets. 7. Expungement and retroactivity. Due process requires full restitution. The jurisprudence of retroactivity, as discussed in Teague v. Lane, 489, U.S. 288, 1989, Montgomery v. Louisiana, 577, U.S. 190, 2016, and Welch v. United States, 578, U.S. 120, 2016, holds that substantive changes in law must be applied retroactively to final convictions. Cannabis legalization, where it recognizes the substance's prior prohibition as unfounded, triggers a constitutional obligation to void all related convictions and restore all attendant rights. Furthermore, the concept of procedural fairness articulated in Goldberg v. Kelly, 397 U.S. 254, 1970, requires meaningful mechanisms for reparative relief. Any framework that denies automatic expungement, or fails to provide restitution for time served, lost income, or civil disability sustains a constitutional wound. 8. Universal licensing or no licensing at all. A right, once recognized, cannot be commodified into privilege without violating the Equal Protection Clause. As held in Shuttlesworth v. City of Birmingham, 394 U.S. 147, 1969, the state may not condition the exercise of a constitutional right upon a license granted by arbitrary authority. Cannabis use, cultivation, and commerce once decriminalized must be accessible to all persons equally, without gatekeeping based on wealth, social status, or geographic location. 9. Conclusion. Constitutional consistency, and the indivisibility of freedom. The Constitution does not permit partial liberty, nor does it recognize tiers of justice. Where the law once erred by criminalizing a natural, ancient, and essential substance, the correction must be total, equitable, and restorative. Equal cannabis freedom is not a policy, it is a constitutional mandate. All licensing regimes, enforcement mechanisms, or market barriers that exclude individuals based on wealth, race, geography, or past convictions are constitutionally suspect and must be dismantled. The United States must not repeat the errors of emancipation without restitution, desegregation without equity, or enfranchisement without inclusion. This chapter affirms the indivisibility of freedom and the constitutional necessity of making cannabis rights universal, unconditional, and irrevocable for everyone, without exception of any kind. Chapter 5. Irrefutable right to heal. cannabis, children, and the reclamation of personal medical liberty. For centuries, cannabis was not a crime, it was a cure. Before the rise of federal prohibition and the political perjury that falsely rebranded this plant as dangerous, cannabis was freely grown, openly prescribed, and widely respected. The families who cultivated it, the doctors who recommended it, and the apothecaries who sold it were not lawbreakers, they were healers, caretakers, and practitioners of empirical wisdom. 1. Historical foundation. Cannabis as common medicine. In the United States and abroad, cannabis had long been part of the medical pharmacopoeia. As far back as the 19th century, it was a foundational component of American medicine. The U.S. Pharmacopoeia listed cannabis sativa from 1850 until 1942 as a treatment for ailments including pediatric epilepsy, neuropathic pain, gastrointestinal disorders, menstrual cramps, muscular spasms, insomnia, and mental agitation. Primary providers of cannabis to children before prohibition included 1. Parents who grew and prepared cannabis remedies for their children's seizures, pain, or anxiety. 2. Physicians who prescribed cannabis extracts and tinctures for children and adults alike. 3. Apothecaries who provided standardized cannabis-based medicines to communities. This was not some underground movement, it was the standard of care. 2. The turning point. The fraud of prohibition. Cannabis prohibition did not arise from science, medical caution, or public health concern. It was birthed in racial animus, corporate monopolism, and bureaucratic ambition. The Marijuana Tax Act of 1937, engineered by Harry Anslinger, was rooted in racist fear-mongering against Black and Mexican populations, corporate lobbying from timber and pharmaceutical giants threatened by hemp and home remedies, propaganda campaigns devoid of scientific credibility. This was compounded by political perjury. The federal government knowingly and intentionally misrepresented cannabis's safety and utility in public testimony. This violated the ethical and legal principles of informed governance. See Gonzalez v. Reich, 545 U.S. 1, 2005, where the court upheld federal control even over homegrown cannabis meant for personal medical use, despite direct state-level protections. The dissent warned of federal overreach into personal liberty and health autonomy. 3. Medical reaffirmation in modern science. Scientific consensus today vindicates our ancestors. Cannabis is a powerful anticonvulsant, proven in pediatric epilepsy, CFDA-approved Epidiolex, an effective analgesic, chronic pain relief without lethal overdose potential, neuroprotective and anti-inflammatory, far safer than most pharmaceuticals prescribed for the same symptoms. This is not anecdote, it is data reaffirmed by peer-reviewed research, global medical practice, and real-world outcomes. 4. Constitutional and natural rights framework. Cannabis freedom is not a matter of regulatory privilege, it is a fundamental right. Under substantive due process doctrines of the 14th Amendment, individuals have the right to bodily autonomy, especially regarding medical treatment. C. Cruzen v. Director, Missouri Department of Health, 497, U.S. 261, 1990. The right to refuse or accept treatment. Griswold v. Connecticut, 381, U.S. 479, 1965. Privacy in personal health decisions. Roe v. Wade, 410 U.S. 113, 1973. Extended bodily autonomy as a liberty interest, even though overturned. Its reasoning still shapes debates of medical self-determination. Cannabis prohibition and legalization violates these precedents. It criminalizes rational health choices, undermines parental rights, and impedes access to life-saving therapies. 5. WHO stood in the way of healing. It was not the parents, it was not the doctors, it was not the healers, it was the government. The same government that later used militarized police units to raid homes of desperate families seeking relief through cannabis. The same government that lied, coerced, and imprisoned citizens under unjust laws based on no valid constitutional authority. 6. The illegality of legalization. To now legalize what was never legally prohibited by just unconstitutional means is not a remedy, it is an insult. As stated in Marbury v. Madison, 5 U.S. 1 Cranch, 137, 1803, a law repugnant to the Constitution is void. Therefore, the prohibition of cannabis was void ab initio nul from the beginning. The act of legalizing it today is a continuation of fraud, not a correction of justice. 7. The mandate for reparation and restoration. The government's crimes against cannabis users, especially the sick, the young, and the dying, demand more than policy change. They demand constitutional redress, full expungement of cannabis convictions, economic reparations for those incarcerated, restoration of parental rights interfered with by prohibition, immediate descheduling and recognition of cannabis as a natural right. 8. Equal freedom for all without exception. No law may divide a natural right by class, race, income, geography, or licensing, cannabis freedom must be absolute. It must be reclaimed, not granted, because government never had the moral or constitutional authority to criminalize it in the first place. We don't seek approval, we assert truth. Truth that predates bureaucracy, withstands propaganda, and stands as a testament to every family that ever fought to heal a loved one, while a corrupt state criminalized their mercy. We do not beg for justice, we declare it. Free people always have. Cannabis is not contraband, it is not a vice, it is not a privilege, it is a right. Cannabis belongs to everyone, without exception. This is child protection via families and family doctors, not child exploitation from corrupt government bureaucracy.
Capítulo 6. La libertad cannabis, un derecho constitucional y médico en España y su interconexión con el derecho internacional.
Chapter 6. Cannabis freedom, a constitutional and medical right in Spanish, and its interconnection with international law.
Introducción. Reafirmación de la importancia del término cannabis, la distorsión de la terminología legal histórica, de marihuana a cannabis, y sus implicaciones en la práctica judicial y médica, como una forma de fraude legal generacional. Reflexión sobre el lavado de cerebro generacional, cómo el término marihuana ha sido empleado como una herramienta para fines raciales y políticos, más que para un entendimiento médico legítimo. 2. Marco jurídico de cannabis en España. La Constitución Española de 1978, disposiciones clave en cuanto a los derechos fundamentales relacionados con la salud, el bienestar y la autonomía individual. Artículos fundamentales relacionados con los derechos a la salud y la libertad individual, artículos 15, 43, 46, 53. Artículo 15. El derecho a la vida y la integridad física como fundamento del derecho a acceder al tratamiento médico adecuado, incluida la cannabis. Artículo 43. El derecho a la protección de la salud. Artículo 46. Responsabilidad del Estado en la conservación del medio ambiente y la promoción de prácticas saludables. Ley 17.967, de 8 de abril, sobre estupefacientes, primer marco normativo que empezó a criminalizar cannabis en España, colocando su prohibición dentro de un marco de estupefacientes peligrosos. Debate sobre la falta de evidencia científica para criminalizarla en su totalidad. Ley 3/2021, de 24 de marzo, por la que se regula el uso terapéutico del cannabis. El avance hacia la regulación del uso medicinal del cannabis en España, permitiendo su uso en tratamientos médicos bajo estrictas condiciones. Implicaciones legales de la prescripción de cannabis para enfermedades crónicas, dolor y trastornos neurológicos. Condiciones para la fabricación y distribución legal de productos derivados del cannabis. 3. Cannabis y la medicina en España. El uso histórico de cannabis en la medicina tradicional española, desde su uso en tinturas y aceites para aliviar el dolor y tratar diversas enfermedades hasta la regulación moderna, remedios de hierbas y el rol de los farmacéuticos y médicos tradicionales que prescribían cannabis como un remedio eficaz. El retorno a la evidencia científica, estudios recientes que reafirman la eficacia de cannabis en el tratamiento de enfermedades como la epilepsia, dolor crónico, esclerosis múltiple y cáncer. Investigaciones médicas españolas, instituciones y estudios que documentan los beneficios del cannabis medicinal. Ley de Garantías y Uso Racional de los Medicamentos, Ley 29/2006, de 26 de julio, regula la utilización de medicamentos, incluyendo aquellos derivados del cannabis. Consideración de los derivados del cannabis como medicamentos bajo prescripción médica. El sistema sanitario español y la regulación de la distribución. Cómo el sistema de salud español regula la distribución de productos derivados del cannabis para uso médico, tanto en hospitales públicos como en farmacias autorizadas. 4. Los implicados en la distribución de cannabis medicinal. Los médicos y su responsabilidad legal. El rol fundamental de los médicos en la prescripción de cannabis y cómo la legislación española determina su facultad para recomendar este tratamiento. Las farmacias y la legislación de distribución. Farmacias como punto de acceso legal para los pacientes que requieren cannabis medicinal, y el procedimiento para obtener prescripción. La ética médica y la autonomía del paciente. La importancia de respetar la autonomía del paciente en la elección de tratamientos, incluidas las terapias con cannabis. El uso recreativo de cannabis en España y su regulación. La regulación en la sociedad española, en comparación con otros países de la Unión Europea, España tiene un enfoque único sobre el uso recreativo de cannabis, basado en el modelo de clubes de consumidores. Ley de clubes de cannabis, clubes privados en los que los miembros pueden cultivar y consumir cannabis de manera legal. El problema de la ilegalidad en lo privado y la falta de consenso político, dificultades legislativas para regular plenamente el uso recreativo, y la creciente presión para una legalización más abierta. La discrepancia entre la legalidad y la realidad del consumo de cannabis. El consumo de cannabis en la vida cotidiana y cómo la ley debe adaptarse a los cambios en la percepción pública y científica. 6. Cannabis, un derecho fundamental. El derecho a la salud y el acceso a tratamientos adecuados. Un análisis de cómo la prohibición de cannabis violó el derecho constitucional a la salud, estableciendo un paralelismo con el derecho a otros medicamentos esenciales. El principio de no discriminación, la necesidad de tratar a los usuarios de cannabis de la misma manera que a los usuarios de otros medicamentos prescritos, sin penalización o marginación social. El rol del Estado en la protección del bienestar, la responsabilidad del Estado español en garantizar que todos los ciudadanos tengan acceso a alternativas médicas legales y seguras. 7. Desmitificando marihuana, el fraude lingüístico y legal. La génesis del término marihuana, la historia detrás de la criminalización del cannabis en la década de 1930, basada en el racismo y la xenofobia hacia las comunidades latinas, y el uso del término marihuana para deslegitimar y demonizar la planta. El lenguaje como herramienta de control, cómo la manipulación del lenguaje alrededor de cannabis en los Estados Unidos y en otros países contribuyó a una narrativa negativa que dañó las políticas públicas. El perjurio generacional del gobierno, la repetida violación de la ley por parte de los gobiernos al seguir usando una terminología errónea y mantener la criminalización de cannabis, violando derechos fundamentales. 8. Conclusiones, el derecho a la libertad y la justicia. Restaurar el acceso y la justicia para los afectados por la prohibición, la necesidad de restaurar la equidad para los usuarios de cannabis y los afectados por la prohibición. Una llamada a la acción para la reforma legal completa, plantear que, aunque España ha avanzado en la regulación médica del cannabis, aún queda trabajo por hacer para eliminar todas las restricciones innecesarias que limitan el acceso total a la planta. Este capítulo se elaborará con la máxima profundidad legal y académica, utilizando referencias precisas a los textos legales relevantes y sus implicaciones tanto en la ley española como internacional. Aseguraré que sea largo, detallado y comprensivo. Por favor, confirma si este esquema te parece adecuado o si deseas más modificaciones antes de comenzar a redactarlo.
Chapter 7, Synthetic THC, Legal Violations, Weaponization of Terminology. 1. Synthetic imposters. Legal ramifications. Cannabis, a natural and ancient plant used for a variety of purposes from medicine to recreation, has been long sidelined in favor of synthetic alternatives that purport to mimic the effects of tetrahydrocannabinol (THC). Synthetic THC, a lab-manufactured counterpart to the natural compound, has seen a rise in the pharmaceutical market, yet these synthetic variants betray not only the integrity of a plant that has existed for millennia, but also the profound legal violations committed by government bodies, pharmaceutical companies, and lawmakers. Creation and distribution of synthetic THC drugs, tracking their chronological development, the companies behind them, and the systemic violations that have occurred in their production and marketing. Legal repercussions of promoting synthetic THC over the natural substance, cannabis, are far-reaching, and a stain on legal history. 2. A chronological examination of synthetic THC drugs. To truly understand the legal transgressions surrounding synthetic THC, we must first catalog the products developed, the years they entered the market, and their companies. 1. Levonorgestrel. Release date 1980s. Investigational. Company Pfizer. Details: investigated for antiemetic and analgesic properties, but never marketed. Levonorgestrel was an early synthetic cannabinoid, produced with the intention of mimicking the effects of natural THC. While it was never commercially available, its very creation stands as a testament to the early shifts in drug policy and regulation that prioritized synthetic over natural compounds. 2. Marinol. Dronabinol. Release date 1985. Company: Unimed Pharmaceuticals, later acquired by Solvay Pharmaceuticals, now part of AbbVie. Details: approved by the FDA to treat nausea and vomiting from chemotherapy and appetite loss in AIDS patients. Marinol was the first FDA-approved synthetic cannabinoid, effectively marking the point at which natural cannabis was sidelined in favor of synthetic alternatives. While the FDA approved this drug for specific medical uses, it highlighted the government's failure to acknowledge cannabis as a viable treatment in its whole, natural form. 3. Sesamit. Nabilone. Release date 1985. Company: Eli Lilly and Company. Rights later acquired by Valiant Pharmaceuticals, now Bausch Health. Details: Nabilone, a synthetic cannabinoid, was introduced for chemotherapy-related nausea and vomiting. Like Marinol, Sesamit was viewed as a safer, more controllable alternative to cannabis, further cementing the notion that natural remedies were unfit for widespread use. 4. Dexanabinol. Release date 1990s. Investigational. Company: Pharmas Corporation. Details: a synthetic cannabinoid researched for neuroprotective effects, particularly in traumatic brain injury. It was never commercially available but represents the growing interest in synthetically recreating the effects of cannabis. The development of such drugs occurred without addressing the obvious legal and medical benefits of using natural cannabis. 5. Namisol. Release date 2010s. Company: Echo Pharmaceuticals. Details: a tablet form of synthetic THC designed for easier administration and more consistent dosing. This further highlights the preference for synthetic over natural, while ignoring the broader medicinal applications of whole plant cannabis. 6. Syndris. Liquid dronabinol. Release date 2016. Company: Inces Therapeutics. Details: a liquid version of dronabinol, approved for treating the same conditions as Marinol. This synthetic THC alternative provided a controlled dosage form, solidifying synthetic cannabinoids as the preferred treatment in certain contexts, despite growing evidence of the benefits of the plant itself. 7. Dronabinol oral solution. Release date 2017. Company: Par Pharmaceutical, a subsidiary of Endo International. Details: a generic oral solution of dronabinol, further commodifying synthetic THC, while leaving the natural plant behind. These developments were not simply a series of innovations, they represent an egregious breach of legal, medical, and ethical standards. These companies capitalized on the synthetic versions of THC to maximize profits, while society and patients were denied access to the natural alternative, cannabis, which would have been the more effective and holistic treatment. 3. Cannabis versus synthetic THC. Legal violations and human rights. Cannabis is not a drug, it is a plant, a whole food, a medicinal herb, and a sacred resource used by humans since before written language. The difference between cannabis and synthetic THC drugs is profound. Yet, pharmaceutical companies, in collusion with governments, have perpetuated a narrative that positions synthetic alternatives as safer, more reliable, and more scientifically legitimate than the plant itself. 1. Violation of human rights: the human right to access safe, effective, and natural medicine is unequivocally enshrined in international law. Yet, the prohibition of natural cannabis and the endorsement of synthetic alternatives represents a flagrant violation of these rights. The United Nations Universal Declaration of Human Rights (UDHR), Article 25, affirms the right to the highest attainable standard of health and medical care. By criminalizing the use of cannabis while endorsing synthetic THC, these laws intentionally deny people their right to natural treatments and healthcare options. 2. The war on drugs and systemic racism. The criminalization of cannabis, rooted in racial prejudice and cultural bias, has disproportionately affected minority communities, especially Black and Latino populations. This policy is enshrined in the Controlled Substances Act, CSA, and reflects both a legal and moral failure on the part of the government. By allowing synthetic THC to flourish while leaving cannabis illegal, the state continues a legacy of criminalizing marginalized communities while profiting from a synthetic substitute. 3. The legal fraud of synthetic THC. Synthetic cannabinoids, such as Marinol and Sesamit, are marketed under the assumption that they are safer than natural cannabis. However, medical and legal professionals alike acknowledge that the entourage effect, the synergy of cannabinoids and terpenes present in the whole plant, is lost in these synthetic formulations. Synthetic THC lacks the breadth of medicinal properties that natural cannabis provides, thus violating the principles of medical ethics. By offering incomplete treatments, the FDA's approval of these drugs without considering the full range of cannabis's natural effects demonstrates a failure to properly regulate the medical industry, prioritizing corporate interests over patient welfare. 4. The principle of equivalence in law. Legal systems globally recognize the principle of equivalence in the treatment of substances with similar effects. By classifying synthetic THC as legal while maintaining the illegal status of natural cannabis, the law creates an unjust and inequitable system. The U.S. Constitution's Equal Protection Clause and Spain's Constitución Española, Article 14, both demand that like substances be treated equally under the law. Thus, the legal classification of cannabis as a dangerous drug while permitting synthetic THC drugs represents a legal violation of equality and fairness. 4. The future of cannabis and legal reform. It is clear that the criminalization of cannabis, while synthetic THC is allowed to proliferate, constitutes a systemic failure. The truth is, synthetic THC products are not merely a stand-in for the natural plant, they represent a perversion of the natural order, designed to perpetuate a cycle of legal and financial exploitation. The synthetic cannabis industry has wrongfully profited at the expense of patient health, government legitimacy, and human rights. A complete reformation of the legal status of cannabis is necessary to rectify these historical wrongs. By legally recognizing cannabis as a natural plant with myriad medical uses, lawmakers will not only correct their past mistakes, but will also help to restore justice to millions who have been harmed by the misguided war on drugs. 5. Legal and ethical imperative to void legalized marijuana prohibition of cannabis. Synthetic THC is a flawed imitation of a natural substance that has been integral to human health, culture, and history for thousands of years. Legal violations that have occurred as a result of its criminalization are profound and irreparable. We have only scratched the surface, but it serves as a call to action for legal reform, urging policymakers and citizens alike to reconsider the legal status of cannabis. Only when the natural plant is fully and freely respected, and its medicinal properties recognized, will the egregious wrongs done to individuals and communities begin to heal. Documentation of the legal failures and unethical practices that have plagued the synthetic THC market. It is time to bring these violations to light, hold accountable those responsible, and ensure that future generations no longer suffer the consequences of a government so entrenched in dangerously criminalizing and nefariously legalizing our natural life-sustaining plants. Chapter 8. Government Cannabis is the Black Market, a legacy of contradictions. 1. Paradox of terminology and control. In recent years, another shift has occurred in the language and legal standing of cannabis, a shift that underscores a far larger and more troubling issue: the government's entanglement with the black market. Government-run cannabis programs, often hailed as a victory for reform, are not a clean break from the very same free market they purport to end. The reality is far more complex, as the government's inconsistent use of the terms marijuana and cannabis over the years mirrors its deeply entrenched relationship with the free market. In fact, government cannabis programs, by any legal or practical standard, are often indistinguishable from the illicit market they claim to replace. Government's shifting terminology and its implicit endorsement of the black market, from the criminalization of cannabis in the early 20th century to its eventual legalization in several states, the government has repeatedly perpetuated an environment where the supposed black market thrives, sometimes through explicit policy decisions, and other times through the language they choose. Cannabis and marijuana, though ostensibly two terms for the same plant, have been used as tools of control, and in doing so, the government has inadvertently become and sustained the very black market it claims to oppose. 2. A historical examination of government cannabis terminology. The government's terminology regarding cannabis has shifted throughout the 20th and 21st centuries, often in direct response to political, racial, and economic pressures. This inconsistency, both in language and policy, has had profound implications for the cannabis industry, the free market, and the general public's understanding of the plant. The introduction of the term marijuana 1930s. In the 1930s, the United States government began its campaign against cannabis, which culminated in the Marijuana Tax Act of 1937. The use of the word marijuana, often spelled marijuana in early texts, was a deliberate strategy to distance cannabis from its more widely accepted name and image as a medicinal and agricultural plant. By the late 1930s, marijuana had become synonymous with criminality in the public imagination, in part due to a concerted campaign led by figures like Harry Anslinger, the first commissioner of the Federal Bureau of Narcotics. Anslinger, a staunch prohibitionist, was instrumental in associating marijuana with criminal activity, using racially charged language to depict its use as a menace, particularly among Mexican immigrants and African Americans. This marked the beginning of a long history of criminalizing cannabis, specifically under the name marijuana. Ironically, this was also the beginning of the free black market for cannabis. Once criminalized, the illicit trade in marijuana became a multi-billion-dollar industry. 2. The Hemp for Victory campaign 1942. World War II provided a curious moment of reversal. During the war, there was a critical need for hemp for military purposes, including for making ropes, uniforms, and other materials essential to the war effort. The U.S. government, in a surprising about-face, launched the Hemp for Victory campaign, urging farmers to grow hemp for the war effort. The government even released a film encouraging the cultivation of hemp. At this point, hemp, a non-psychoactive variety of cannabis, was briefly rebranded as a necessary agricultural commodity. However, this reversal was short-lived, and after the war ended, the government's stance quickly returned to its aggressive stance against marijuana, leaving hemp in legal limbo for decades. 3. The War on Drugs era and the return of marijuana 1970s–1980s. In the 1970s and 1980s, the federal government's stance on marijuana was heavily shaped by the escalating war on drugs. The term marijuana remained heavily demonized, while cannabis was increasingly pushed to the periphery. The Marijuana Tax Act was replaced by the Controlled Substances Act of 1970, which classified marijuana as a Schedule I drug, making it illegal for any purpose. During this time, marijuana continued to be associated with criminal behavior, a product of the black market, and its use continued to be criminalized on a federal level. However, by the early 1990s, growing public awareness of cannabis's medical uses, as well as the advent of state-level medical cannabis laws in California, began to change the narrative. Yet, even as states began to legalize cannabis for medical purposes, the federal government continued to use the term marijuana to maintain its prohibitionist stance. 4. The shift to cannabis in the 21st century, 1990s to present. With the advent of the 21st century, the language surrounding cannabis began to evolve once more. Activists, academics, and medical professionals pushed for a shift from marijuana to cannabis, recognizing the latter term's more neutral connotations and broader legal and historical significance. By the early 2000s, advocates for cannabis reform began to use the term cannabis as a way to move away from the stigmatizing term marijuana. This shift was also fueled by increasing recognition of cannabis as a legitimate medicinal plant. 5. Modern legalization movement, return of marijuana. Despite the growing acceptance of the term cannabis, the government has been slow to adapt. In the years since the early 2000s, marijuana has once again entered the public lexicon as many states began legalizing it for medicinal and recreational use. Politicians and public health experts, however, continued to refer to it as marijuana in legal and legislative contexts. Even as cannabis was legalized in numerous states, it was still largely referred to as marijuana, perpetuating the same stigmas and misunderstandings that had been in place for decades. Ironically, government legalization efforts have often been framed within the same ideological context that once criminalized marijuana, casting doubt on the authenticity of the reform. 6. Cannabis and marijuana as black market synonyms. The most egregious contradiction lies in the fact that government-regulated marijuana, or cannabis, is, in effect, the black market in legalized form. Governments continue to impose heavy taxes, regulations, and artificial barriers to entry in the legal cannabis industry, creating a gray market and leaving much of the trade in the hands of illicit players. In California, for example, legal cannabis prices have soared due to heavy taxation, prompting many consumers to turn to the free market for lower-cost products. Even more strikingly, many of the same companies and individuals who once sold cannabis illegally are now operating legally within the confines of government regulations, operating essentially as legalized black market actors. This paradox leaves us with a question: is government cannabis truly different from the black market, or is it simply a way to generate revenue for the state, keeping the same criminality intact? 3. The black market government cannabis system, economic and legal implications. Economic implications, taxation, and the legal black market. The government's taxation policies on legal cannabis products have pushed many users back to the free market. High prices due to taxes, fees, and regulations have incentivized free trade, even in states where cannabis is legal. The legal cannabis market is constantly undercut by cheaper, untaxed products that are often grown, distributed, and sold freely. This creates an economic ecosystem where both legal and illegal markets coexist, reinforcing the black market economy. 2. Legal implications. Contradictions in the law. While cannabis is legal in certain states, it still pretends to be illegal under federal law. The fact that legal cannabis markets coexist with illegal markets in the same regions creates a glaring contradiction in the legal system. The federal government continues to prohibit the plant, which directly supports the free market by driving individuals and businesses to engage in free market activities to meet demand. 3. Social implications. The stigma persists. Despite the changing legal landscape, the stigma surrounding cannabis remains. The persistent use of the term marijuana in legal contexts, combined with the complex, patchwork legal status of cannabis, perpetuates societal misconceptions about the plant. This stigma continues to fuel both the free market and the criminal justice system's disproportionate targeting of marginalized communities, especially Black and Latino populations, for cannabis-related offenses. 4. Paradox of government cannabis as the black market. In conclusion, the shifting terminology and policies surrounding cannabis have created a unique paradox. While the government has made strides in legalizing cannabis in certain jurisdictions, it has also inadvertently supported and perpetuated the black market through convoluted laws, high taxes, and inconsistent language. The very act of government cannabis regulation, while legally sanctioned, can be seen as an extension of the same black market it is supposed to replace. Ultimately, the government's approach to cannabis, whether called marijuana or cannabis, serves as a reminder of the deep contradictions at play. To truly end the black market, a comprehensive reevaluation of cannabis laws, taxes, and public perceptions is needed. Only when prohibitive cannabis laws are nullified, cannabis is fully decriminalized and treated on par with any other plant or commodity, can we hope to see an end to the government black market in its entirety. Chapter 8, Part 2. Government marijuana is the black market, the unseen conspiracy of control. 1. Introduction, a wake-up call to a system of inherited lies and subjugation. Let us not sugarcoat the truth any longer. The government's cannabis programs are not a step toward liberation, they are a continuation of the very mechanisms of control, suppression, and exploitation that have defined cannabis's tortured history in the United States and globally. These programs, which purport to replace the black market with government-regulated cannabis, are nothing more than a rebranded version of the same illegal, underground market, wearing a government-issued suit and tie. The government's shifting terminology around cannabis, whether it is called marijuana, hemp, or cannabis, has consistently been used as a tool of control, manipulation, and subjugation. Each flip of terminology, each change of legal policy, only further entrenches the government's black market, as it sustains the very myths and legal inconsistencies that keep cannabis under the boot of prohibition. If one is to understand the true depth of this systemic betrayal, one must see the larger pattern of deception, manipulation, and state-sponsored criminalization that has been woven into the very fabric of cannabis history to this day. We expose the historical and ongoing illegal, economic, and social mechanisms through which the government continues to endorse, protect, and perpetuate its black market under the guise of legalization. The irony is striking, the contradictions profound. The government, through its own policies, has turned what could be an entirely above-board market into an economic parallel to the supposed black market it has waged a war against for nearly a century. Indeed, government marijuana, government cannabis, is the black market, and it is long past time more face that uncomfortable historical truth. 2. The rise of cannabis prohibition. From agriculture to criminalization, cannabis was once revered as an agricultural and medicinal resource in the U.S., from ancient civilizations, and for millennia it was considered an essential part of human life. In ancient China, India, and the Middle East, cannabis was cultivated not only for its fibers, but for its medicinal and psychoactive properties. It wasn't until the early 20th century that cannabis began to take on a negative image, largely through a concerted marijuana campaign led by the U.S. government and other Western powers. Marijuana Tax Act of 1937, the birth of a stigma. Marijuana Tax Act of 1937 was the first federal law in the United States to criminalize cannabis. It was not merely a response to any significant social harm, but rather the product of a deep, racially charged fear. Harry Anslinger, the first commissioner of the Federal Bureau of Narcotics, FBN, was instrumental in spearheading this movement. His rhetoric was filled with racial prejudice and paranoia, stoking fears about cannabis being a gateway to crime, violence, and racial degeneration. Anslinger's use of the term marijuana, which was not the commonly used term for the plant, was a deliberate rebranding, designed to associate cannabis with a new wave of fear. By using a term that was foreign to most of the public, and had no prior association with the plant, Anslinger manipulated public perception. The term marijuana became synonymous with crime and deviance, even though it referred to a plant that had been used as a medicine and fiber for centuries. The result of this campaign was a pseudo-legal reality where cannabis was criminalized, and its medicinal and industrial uses were abruptly dismissed. The federal government's decision to criminalize cannabis led directly to the development of government underground, black market for marijuana, a market that flourished as demand persisted despite the plant's fraudulent illegality. It was during this period that the seeds of the government's ongoing development of the black market were sown. 2. The Hemp for Victory campaign, a wartime reversal. During World War II, the U.S. government made a temporary about-face. The demand for hemp, crucial for making ropes, uniforms, and other military supplies, led to the Hemp for Victory campaign. In this campaign, the government actively encouraged American farmers to grow hemp, even producing a film to promote its cultivation. Hemp, however, was still legally distinct from psychoactive cannabis, and this campaign was motivated by the needs of war, not a newfound appreciation for cannabis. Yet, this policy reversal would not last. Once the war ended, the government resumed its campaign against marijuana, reinforcing its criminalization and its own black market that had emerged during the period of prohibition. 3. War on drugs. The government's continued betrayal of cannabis. In the 1970s and 1980s, the U.S. government began what would become the war on drugs, a policy that disproportionately targeted marginalized communities, particularly Black and Latino individuals. Cannabis was at the center of this war, criminalized as a Schedule I drug under the Controlled Substances Act of 1970. Despite overwhelming evidence of cannabis's medicinal benefits and its long history as a non-harmful plant, the U.S. government continued to perpetuate the narrative that marijuana was a dangerous, deadly substance. 1. The inconsistency of legalization efforts. State versus federal law. Throughout the 1990s and early 2000s, states began legalizing cannabis as marijuana for medical use, with California at the forefront. But even as individual states passed medical marijuana laws, the federal government continued to prosecute individuals and organizations for cannabis use as marijuana cultivation and distribution under the Controlled Substances Act. This incoherent and contradictory legal environment perpetuated the conditions under which the government's black market for cannabis could thrive. The very same government that had banned cannabis as marijuana nurtured a government black markets for decades now found itself faced with the consequences of its own laws. As more states passed legalization laws, the federal government's resistance to reform became more transparent. The legalization of cannabis at the state level, while an important step, did little to eliminate the black market. Instead, it created a complex legal paradox where cannabis was both illegal and legal, but where only the people were habitually punished, depending on the jurisdiction. This inconsistency created the perfect storm for a new form of government black market activity, one that operated within the confines of state law but was still illegal at the federal level. 4. The modern era, government marijuana, and the perpetuation of the black market. In recent years, as marijuana legalization has spread across states like wildfire, the government has attempted to position itself as a force for reform. However, it has done so by imposing a web of regulations, taxes, and barriers to entry that have caused prices to skyrocket and encouraged free cannabis operators to flourish. Government marijuana black market programs, both medical and recreational, are not immune to the same systemic inequalities that have plagued the war on drugs. Let us be absolutely clear. Government cannabis and government marijuana is the black market in its most sanitized and rebranded form. The issue of taxes and prices. In states like California, where cannabis is legal for both medical and recreational use, prices are often prohibitively high due to heavy taxation. This leaves consumers with little choice but to turn to the free cannabis market, where prices are significantly lower. The state's attempts to regulate marijuana have only made it less accessible to those who need cannabis the most, driving them back into the cannabis freedom trades that government marijuana is still desperately trying to eliminate. 2. Role of big business in the government marijuana system. Furthermore, the legalized marijuana industry is increasingly dominated by large corporations that have deep ties to political elites and the black market. These companies are able to manipulate the black market system to their advantage, gaining control over the market while small farmers and minority communities, who were disproportionately impacted by marijuana prohibition of cannabis, remain excluded from the industry. This is no different from the government-controlled black market that existed before government marijuana was fraudulently and supposedly legalized. Government's heavy-handed regulation of the marijuana industry has essentially created a corporate oligopoly, ensuring that the profits from legalized marijuana remain concentrated in the hands of a few wealthy individuals and entities, while cannabis freedom markets continue to thrive in the shadows. This is nothing short of a betrayal of the very people who ignorantly fought for legalization in the first place, thinking what they were fighting for was the free market. 5. Legal and social implications. The legacy of the free market in legalization. The legacy of the free market is inextricably tied to the language and policies of the government. Despite the recent shift toward legalization, the underlying social stigma surrounding marijuana persists. The government's inconsistent approach to cannabis terminology, shifting from marijuana to cannabis and back again, has only deepened the stigma. The government's attempt to control the narrative of cannabis with marijuana, often shifting language as needed, has led to a deeply confused and fractured legal system, where the truth about cannabis's freedoms and agricultural value is obscured. Moreover, continuing criminalization of marijuana at the federal level, combined with heavy taxes and regulations at the state level, ensures that free market cannabis will persist as a parallel industry. The government, far from eliminating the free market, which they call the black market, has merely rebranded it, pushing free trade into the shadows while protecting the interests of those who stand to profit from unconstitutional legalized of marijuana. 6. Call to action, reclaiming cannabis freedoms from government's marijuana black market. The truth is undeniable. Government marijuana and government cannabis is the black market. Government's efforts at legalization are riddled with contradictions, inefficiencies, fraud, perjury, and injustices that perpetuate the free markets they seek to eliminate. The time has come to reject this system of hypocrisy and demand truth. Cannabis should not be treated as a commodity controlled by the state or the corporations. It should be recognized for what it truly is: a plant with a long and honorable history that belongs to the people, not to any state or any government. Until cannabis is treated as such, until it is completely decriminalized and the laws surrounding it are truly void, the free market will continue to thrive, hidden in plain sight sometimes under the guise of government regulation. It is time for the public to wake up, to shed their complacency, and to see government marijuana programs for what they truly are: a continuation of the black market, fraudulently legitimized and controlled by those who profit from the oppression and suppression of cannabis culture and its community. The only way to truly end the black market is to end the government's monopoly on our flowering herbal whole food and allow individuals to reclaim their right to grow, consume, and share cannabis freely, without licenses, without taxation, without punishment, and with impunity. Chapter 9: Government Felony Perjury of Terminology and Definitions. 1. Introduction: the deliberate distortion of language and law. It is a well-established truth that language shapes thought, and thought shapes action. In the case of cannabis, this truth has been weaponized by the governments in an orchestrated and deliberate campaign to pervert legal and societal perceptions through the manipulation of terminology and definitions. Felony perjury committed by government officials regarding cannabis terminology is not merely a mistake. It is a calculated systemic distortion aimed at maintaining control over and exclusive possession of a plant that has been used for millennia. Let's discuss how the government has repeatedly committed felony perjury, not only in the criminal context, but in the very language of the law itself, through the manipulation of cannabis terminology and definitions into bogus marijuana terminology and definitions. The power of definition is not a trivial matter, especially in law. It is the foundation upon which law is constructed and dismantled. Thus, the construction of terminology and definitions regarding cannabis as marijuana has had profound and uncounted legal, cultural, and economic consequences. Every time the government changes the terminology surrounding cannabis, whether from cannabis to hemp to marijuana, or from cannabis back to hemp and to marijuana again, it commits another act of felony perjury. This perjury is not just a mere distortion of words, but an intentional obfuscation of the truth about cannabis's historical, medical, social significance, and human rights. This constant redefining is constitutionally repugnant. 2. The origins of the felony perjury: the creation of marijuana. 1. The Marijuana Tax Act of 1937. Felony perjury. To understand the government's felony perjury in the realm of cannabis terminology, one must first trace the origins of the word marijuana. The term marijuana was not the widely accepted name for cannabis in the United States prior to the 1930s. Cannabis, known by various names such as hemp, Indian hemp, or cannabis sativa, had been used for centuries for medicinal, industrial, and personal and spiritual purposes. However, it was not until the 1930s that the U.S. government deliberately changed the terminology to marijuana to create an association with Mexican immigrants and racialized fears. This was a political move designed to stigmatize and criminalize the plant, associating it with ethnic minorities, particularly the Mexican and black populations. Felony perjury in the Tax Act of 1937. By using the term marijuana in the Marijuana Tax Act of 1937, the government committed its first felony perjury. The act sought to criminalize cannabis under a new name that had never before been associated with the plant. The term marijuana and marijuana was hijacked foreign vernacular inserted into U.S. law. This created confusion in the English-speaking public. Legal perceptions of cannabis, and the term marijuana would remain a tool of governmental distortion for decades to come. It still is. By redefining a plant that had been in widespread use for centuries as a new and dangerous substance, the government willfully constructed false narratives. This was not an innocent mistake, but a purposeful and dishonest maneuver to justify criminalization and slavery. Marijuana Tax Act was the beginning of a long-standing campaign by the U.S. government to legally and culturally misrepresent cannabis, starting with the falsification of terminology and definitions. This was a deliberate act of perjury because the legal system, with all its weight, was used to redefine the very nature of cannabis, thus perpetuating falsehoods for generations. 3. The shifting terminology, from hemp to marijuana, and back again. The inconsistency in cannabis terminology is not merely historical, it continues to evolve today. The government's continued flip-flopping between terms like marijuana, hemp, marijuana, and back to cannabis is a direct identifier of government felony perjury, a consistent practice of linguistic deception designed to obscure the truth. Hemp for Victory and the Wartime Reversal. Hemp for Victory campaign during World War II briefly reinstated the use of hemp and cannabis for industrial purposes, with the government encouraging farmers to grow hemp for military supplies. During this time, our plant was recognized for its industrial value, yet the stigma surrounding marijuana was still so deeply ingrained that the distinction between hemp and cannabis was maintained. Hemp was not viewed as marijuana, and the government was careful to delineate the two in their wartime push. However, as soon as the war ended, the government resumed its policy of criminalizing marijuana and distorting public perceptions about cannabis, even though hemp and marijuana were both derived from the same plant. Felony perjury in wartime language. By temporarily celebrating hemp, while continuing the criminalization of marijuana, the government engaged in a falsification of cannabis's identity. It was a policy flip meant to manipulate wartime necessities. This was war crime, yet it did nothing to truly address the discrepancies in cannabis terminology and the legal framework surrounding it. Government just tried to eradicate the plant and the cannabis history. 2. The 1970 Controlled Substances Act, the perpetuation of perjury. When the Controlled Substances Act of 1970 was passed, cannabis was classified as a Schedule I substance, which means it was deemed to have no accepted medical use and a high potential for abuse. This federal policy persisted, despite mounting evidence to the contrary. Free use of marijuana continued to be criminalized, despite its long and storied history of impunity in the U.S. as a medicinal and industrial crop. The term marijuana was once again legally defined, and the criminalization of cannabis, as marijuana, continued under federal law. This act was supported and made possible by a new law book. John Kaplan's edition of the Marijuana Report of the Indian Hemp Drugs Commission, 1893 to 1894, was published in 1969 by those Jefferson Publishing Company. This edition includes Kaplan's introduction and glossary, which is nothing like the original British report that was published in 1894. Felony perjury in the CSA. The Controlled Substances Act perpetrated felony perjury by defining marijuana as a drug with no accepted medical use, despite centuries of medicinal use and ongoing research indicating its benefits. The term marijuana was effectively frozen in a negative context, leading to continued legal discrimination against cannabis under the guise of public health and safety. This legal manipulation allowed the government to continue to control and possess cannabis, while also excluding hemp from the definition of marijuana despite both being products of the same cannabis plant. This further perpetuated sickness and slavery. 4. The return of cannabis. A fleeting glimpse of clarity. In recent years, the federal government's definition of cannabis has shifted once again, though the core issues of deception and felony perjury remain largely unaddressed. The 2018 Farm Bill legalized hemp at the federal level, effectively distinguishing hemp from marijuana, yet leaving the question of cannabis itself still embroiled in confusion. The continued federal criminalization of cannabis, even as states, like Colorado, California, and others legalized it for medical and recreational use, highlights the persistent felony perjury surrounding its definitions. The confusion was and is by design. Felony perjury in the 2018 Farm Bill. The 2018 Farm Bill's legalization of hemp might be seen as a victory, but it also creates a false distinction between hemp and cannabis, which is scientifically unsound. By perpetuating the notion that hemp and cannabis are entirely separate substances, the government continues to mislead the public. Hemp, after all, is simply cannabis with low levels of tetrahydrocannabinol, THC. The decision to distinguish them for regulatory purposes and to continue criminalizing cannabis as marijuana, while allowing hemp to flourish, remains an act of felony perjury. The plant, with its complex and multifaceted history, has been systematically stripped of its identity for political purposes. 5. The felony perjury in public policy. Ongoing deception and legal inconsistency. Governmental manipulation of cannabis terminology does not stop at the legislative level. Federal and state agencies alike have contributed to the felony perjury by creating policies that contradict one another and reinforce the continued illegal criminalization of cannabis. This has created an environment in which the public is systematically misled about the true nature of cannabis and its various uses, leading to an ongoing cultural and legal misunderstanding. Federal-state divide. Governmental paradox. Even as states continue to pass legislation legalizing marijuana and cannabis in various forms, the federal government maintains its stance, asserting that marijuana has no legitimate medical use. The legal dissonance between state and federal law perpetuates the government's black market, as it creates confusion and inefficiency in the fraudulently legalized cannabis industry. Federal laws that continue to classify marijuana and cannabis as a Schedule I substance are another form of government felony perjury, because they ignore the substantial body of evidence proving its medical and industrial utility, but most especially the reserved rights and will of the people. 2. War on cannabis users. Ongoing legal discrimination. The government's continued criminalization of cannabis and its inconsistent application of terminology contributes to a system of legal discrimination that disproportionately impacts poor and minority communities. Despite the evidence that cannabis can provide relief for a variety of conditions, the legal system continues to treat its users and cultivators as insane criminals. This legal inconsistency, coupled with medical and racial biases, makes the government complicit in continually perpetuating felony perjury at the highest levels. 6. Reclaiming truth, language, and justice. Government's repeated manipulation of cannabis terminology is nothing short of a felony perjury, a calculated effort to mislead the public and maintain control and possession over a plant that has been mischaracterized for centuries. By intentionally distorting definitions, the government has created a false narrative about cannabis, its users, and its potential. The time has come for this system of linguistic manipulation and legal injustice to end. Cannabis is an unalienable, historically evident, right reserved by free people since before written language. No amount of government fraud nor prohibitive legalization will ever change this. It is imperative that governments take full responsibility for the felony perjury they has committed through language, laws, and policies regarding cannabis. Only through full decriminalization, prohibition nullification, re-education, and a truthful redefinition of cannabis can we hope to correct the egregious legalized crimes that have plagued our society for over a century. The fight for cannabis freedom is not just a legal issue, it is a fight for truth, for justice, and for the right to reclaim a plant that has been unjustly demonized. Chapter 9, Part 2, The Perjury of Kaplan and Anslinger. 1. Introduction. The Architects of Deception. Examination of government felony perjury. 2 notorious figures who played a pivotal role in the distortion of cannabis terminology into marijuana terminology and public perception during the early 20th century. 2 names stand out in this regard: John Kaplan, a Stanford law professor, and Harry Anslinger, a key witness who willfully perjured himself before Congress. These individuals, through their deliberate misrepresentations, became instrumental in perpetuating the criminalization of cannabis as marijuana and reinforcing the false narratives surrounding its dangers. Their willful perjury, their disgraceful testimony, backhanded compliments directed towards all governments that funded and propagated their lies. 2. The roots of Kaplan's deception, legalizing lies for the state. John Kaplan's role in the Indian hemp drug report. John Kaplan, a professor of law at Stanford University, was no stranger to the intricacies of legal manipulation. His development of the marijuana report of the Indian hemp drug report, which compared the purported dangers of cannabis with those of more harmful substances, was pivotal in shaping the public's perception of the plant as a deadly menace. This report was presented to Congress as an official account, and Kaplan's endorsement of its findings lent an air of academic credibility to what was, in reality, a compilation of fabricated horrors. Kaplan's participation in this lie was not the result of ignorance. His awareness of his misrepresentations being made is evident in his subsequent actions. By agreeing to publish and promote the report, Kaplan knowingly perpetuated a narrative designed to criminalize cannabis as marijuana and prevent any serious discourse on its medicinal and industrial uses. His actions, which may have seemed like innocuous academic engagement to some, were far from innocent. It was fraudulent and felonious. Felony perjury by Kaplan. A master of deceit, Kaplan's academic standing gave his testimony weight in the eyes of the public, but it was built upon a foundation of willful perjury. He did not merely misrepresent the facts, he actively contributed to the distortion of truth about cannabis for political and social gain. His support and subsequent perjury of his own of the marijuana report of the Indian hemp drug report served as a primary tool in reinforcing the racial and social biases that fueled the criminalization of cannabis. With every word he spoke, he willfully betrayed the truth and the public trust. His involvement in the report laid the groundwork for further deception, and Kaplan's legal expertise was exploited to protect the government's interests that relied on perpetuating lies about cannabis for control and profit. Kaplan's perjured marijuana version became the authoritative law book in the U.S., whereas the original British version was just a report, not a strictly enforceable legal document. 3. The testimony of Harry Jacobs, a complicit perjurer. Harry Jacobs, a key witness brought before Congress during the 1930s hearings on cannabis, played an equally reprehensible role in this government-sanctioned campaign of misinformation. Jacobs, who served as a prosecutor and public figure, testified with a conviction that would have seemed admirable in a courtroom setting had it not been based on complete falsehoods. In his testimony, Jacobs claimed that cannabis was deadlier than a rattlesnake, and presented a narrative that mirrored the exaggerated fears circulating in the media. His statements were a direct affront to the truth, as they were based on his own unfounded personal biases and racist affinity rather than objective research. In doing so, Jacobs willingly perjured himself, knowing full well that his claims lacked any basis in scientific fact. Felony perjury by Jacobs, the power of a false narrative. Jacobs' inflammatory remarks were not just an attempt to deceive, they were a deliberate attempt to manipulate public opinion and ensure the continuation of policies that criminalized the plant and funded his ignorant war. By equating marijuana with venomous snakes, Jacobs sought to paint it as a monster lurking in society, waiting to strike. This emotional rhetoric was designed to create fear and support the legal framework that would lead to the eventual passage of the Marijuana Tax Act of 1937. Jacobs, like Kaplan, had no excuse for his actions, only greedy self-aggrandizing motivations. His role in perpetuating government lies was not one of ignorance, it was a calculated and willful decision to participate in the criminalization of a plant that had been used for centuries. His testimony remains a stain on American legal history, one that has perpetuated lies surrounding cannabis for generations. 4. Backhanded compliments to the government from the people. The government's role in perpetuating these lies, both through Kaplan's and Jacobs's testimony, has long been a source of frustration for those who have advocated for cannabis freedoms. It is only fitting that those who sought to challenge these lies should deliver their critiques in a manner befitting the gravity of the situation. Here we reveal the contempt the public and informed experts have for criminal government's actions, while seemingly positive, are in fact deeply cutting critiques of the government's fraudulent role in perpetuating the felony perjury of marijuana, terminology and definitions, while eradicating cannabis and its terminology and definitions. 1. The government's dedication to truth has truly set a new standard in the art of deception, one that future generations will study with awe and admiration. This elegant rebuke, highlighting government's uncanny ability to fabricate and control narratives, while masking these deceptions seem as noble truths. 2. Government's consistency in maintaining its fake stance on marijuana is impressive, like a well-rehearsed play, where the actors never deviate from their script, no matter how much the audience protests in horror and disgust. Subtle insult praises the government's unwavering commitment to its false narrative, likening it to a performance that progressively grows more tiresome and more hollow over time. 3. One must admire the government's skill in keeping the public in the dark after all. No one can see the light when they're buried under an avalanche of carefully crafted lies. Sophisticated jab at the government's relentless efforts to keep the truth hidden, its success in clouding the reality of cannabis's medicinal and historical value. 4. The brilliance with which the government redefines reality itself is unparalleled, demonstrating that even the most deeply entrenched truths can be rewritten, twisted, and subverted by those who hold the dictator's pen. Here, the government is lauded for its power to rewrite history and reality, casting the very concept of truth as malleable and subjective in its hands. 5. It's truly remarkable how the government manages to preserve public order by sowing chaos with misinformation. 1. Can only wonder what kind of progress we might have made had they chosen a truly honorable and noble path. This mocks the government's role in creating confusion and legal disorder, questioning the potential for true progress if honesty had prevailed. 6. Government's restraint in acknowledging the truth is truly commendable. Why waste resources on facts and with efficiencies when it's so much easier to build a system of control and subjugation upon convenient lies? Government's reluctance to engage with the truth, instead opting for a system built on convenient falsehoods that serve its self-destructive interests. 7. In their tireless efforts to prevent the public from discovering the truth, the government has certainly demonstrated that no stone is left unturned except, of course, the one upon which the truth rests. Remark acknowledges government's exhaustive efforts to suppress the truth while hinting that it purposefully overlooks the most important and foundational facts. 5. Conclusion. The enduring legacy of legalized lies. The lies told by John Kaplan and Harry Anslinger, as well as the willful perjury committed by the government throughout the 20th century, are not relics of the past. They continue to shape the legal landscape surrounding cannabis to this day. The perjury committed in the halls of Congress and the courts has created a legal environment in which cannabis is seen as a dangerous, criminal substance, despite all evidence to the contrary. Backhanded actions and deep-seated frustration that so many feel towards the government. We are reminded that truth cannot be suppressed forever. The time for legal nullification is now, and it must be built upon honest terminology and definitions of cannabis, one that recognizes the historical, medicinal, and industrial significance of the plant. This day is here, it has finally come, it is today. Government's legacy of felony perjury will continue to hang over the heads of those who fight for justice and truth about cannabis. Chapter 10. Cannabis proper medical English legal name, and its diminishment through prohibition propaganda. 1. Introduction. Etymological significance of cannabis. The name cannabis has a long history, dating back centuries, and it has always been recognized as the proper scientific, medical, and legal nomenclature for the plant in question. Its use in both common parlance and legal documentation has been consistent and appropriate. However, over the course of the 20th century, a deliberate shift took place. The name cannabis was subordinated, while marijuana was nefariously and artificially elevated. This deliberate shift in terminology and definitions was not a mere linguistic accident, but part of a broader, legal psychological campaign as a result social shift to criminalize and stigmatize the plant and all who used it. Cannabis is derived from the Greek word cannabis, which has been used for thousands of years to refer to the plant's psychoactive and medicinal properties. It was once universally understood and accepted in medical and legal contexts, particularly in reference to its therapeutic benefits. The term marijuana, on the other hand, was forced in the early 20th century with no historical precedents in the field of botany or pharmacology. By intentionally shifting to this less precise, more racially charged term, the government and other interested parties sought to associate cannabis with negative, criminal connotations and violently capitalize on it. We assert cannabis as the proper name and demands its capitalized use in all legal and formal contexts. Through a historical, legal, and linguistic analysis, we will demonstrate that cannabis has always been the correct medical, legal, and scientific term, and that the deliberate diminishment of its status is an abhorrent affront to truth, history, and justice. 2. The historical context. From cannabis to marijuana, and back again. The term marijuana began to emerge during the early 20th century, in the United States, when prohibition propaganda needed a tool to vilify cannabis in the eyes of the public. The Marijuana Tax Act of 1937, which triggered rapid acceleration and significant formal criminalization of cannabis in the United States, played a key role in the shift. The term marijuana was used not only in ignorant legal language, but was frequently written in lowercase to further diminish its importance and associate it with Mexican immigrants and minority communities. This shift in terminology was deliberate and calculated, a strategic move to stigmatize the plant in ways that could justify its prohibition with a masked disguise. The term marijuana was chosen for its association with immigrants, specifically Mexican Americans, and was designed to elicit fear and distrust. The racial undertones were unmistakable, as reports linked marijuana with violent behavior and social deviance, portraying it as a dangerous deadly drug consumed by the poor and marginalized. In contrast, cannabis had long been recognized as the proper botanical, medical, and legal term, well documented in pharmacological texts and medical literature, particularly in the context of its use in the medical profession for pain relief, nausea suppression, and many other therapeutic uses, were valid beyond doubt. This distinction was pivotal. While marijuana came to be associated with criminality and irrational fears, overly suspicious, anandamide deficient, exceptionally skeptical, suspicious, and paranoid persons, cannabis remained scientifically neutral and medical, tied to objective studies and clinical applications. 3. Legal precedents. Why cannabis should be capitalized. The importance of capitalizing the term cannabis cannot be overstated. Legally, terminology is not just a matter of semantics, it influences perception, treatment, and regulations. Over the years, government's manipulation of cannabis vocabulary, lowercasing cannabis, and capitalizing marijuana has had profound legal ramifications, influencing public policy, law enforcement, and healthcare regulations. 1. The Controlled Substances Act of 1970. The Controlled Substances Act, CSA, was a landmark piece of legislation in the United States, establishing the legal framework for the regulation of drugs. Under the CSA, marijuana was classified as a Schedule I controlled substance, which explicitly prohibited its use, cultivation, and distribution. However, this legal framework continued to use the term marijuana in uppercase, further reinforcing the stigma associated with the plant. Cannabis, in its proper scientific context, was virtually ignored in favor of the demonized term and its subsequent unfounded definitions. Legal argument. By allowing marijuana to remain in uppercase and cannabis absent entirely, the law itself perpetuated not only a false dichotomy between the scientific understanding of cannabis, but an insurmountable schism from the racially charged narrative built around marijuana. This diminished the plant's medicinal and scientific credibility and contributed to the long-standing criminalization of cannabis use. 2. Marijuana Tax Act of 1937. One of the most critical moments in this shift in terminology came with the false passage of the Marijuana Tax Act of 1937. The FALS Act, the first federal legislation aimed at criminalizing cannabis, used the term marijuana capitalizing the first letter throughout its text and all of the letters. The entire term was capitalized in the document and on the stamps themselves. Still yet in other places it is lowercasing and quoting marijuana and capitalizing cannabis. It is a very confused document. This linguistic gymnastics was a calculated move to ensure that the plant would remain linked with negative stereotypes. They redefined marijuana as the entire cannabis plant. It redefined the entire name of the plant genius, but only in legal terms, not scientifically, not medically, and not botanically. Legal argument. The Act's choice to uppercase and lowercase marijuana as well as uppercase and lowercase cannabis was deliberate, contributing to the stigmatization of cannabis, which has persisted in U.S. law to this day. The legal adoption of this term over the scientifically appropriate cannabis has reinforced societal misconceptions, legal interpretations, and medical applicability, making it all the more difficult to appropriately challenge the plant's obviously wrongful criminalization in subsequent years. 3. The Drug Enforcement Administration, DEA, and official listings. Despite overwhelming historical presence of cannabis in scientific literature, it was not until more recent years that the legal system began to seriously entertain its medicinal potential. The DEA nefariously continued to use the term marijuana in its publications and regulations, associating the drug with illegality, in the face of informed public opinion and scientific evidence. The corporate entity known as NORML is just a complete government psychological operation and propaganda machine, with no intent to serve the will of the people nor the Constitution, or by now they would have. Legal argument. The continuation of this linguistic error not only perpetuated misinformation, but subverted all efforts to correct the historical misclassification of cannabis as a dangerous, deadly, and illegal substance. By referring to cannabis by the Spanish name marijuana, the law continues to criminally promote the fraudulent criminalization of the flowering plant, rather than engaging with the growing body of evidence supporting its medical applications and human rights respectively. 4. Linguistic distortion, legal repercussions. Manipulation of cannabis terminology has had deep, lingering effects on legal precedent and public perception. The effort to associate cannabis with marijuana through linguistic distortion has been a central strategy in maintaining unrealistic prohibition policies, unconstitutional prohibition revenue, both domestically and internationally. 1. International law and cannabis. Cannabis was regulated under the Single Convention on Narcotic Drugs in 1961, an international treaty that sought to standardize drug control measures across nations. In its early formulations, the term marijuana was used despite the scientific and botanical name being cannabis. This international precedent reinforced the misconception that marijuana, first, and by extension cannabis, second, was inherently dangerous, setting the stage for irrational and manic global prohibition efforts. 2. Legal jurisprudence. In U.S. legal jurisprudence, cases such as United States v. Oakland Cannabis Buyers Cooperative, 2001, where the Supreme Court ruled against medical cannabis use under federal law, perpetuated the use of marijuana over cannabis. Legal scholars have noted that continued usage of marijuana, instead of the appropriate name cannabis, continues to cloud legal clarity regarding its legitimate medical and industrial uses. 5. Linguistic and legal shift. Moving towards cannabis. In the 21st century, the terminology surrounding cannabis is undergoing another shift, unnecessary and overdue. Several states have legalized medical and recreational cannabis, and with this shift, the term marijuana is increasingly being replaced with the more accurate and respectful name cannabis. This re-emerging lexicon is also reflected in the United Nations Office on Drugs and Crime, UNODC, which has embraced the term cannabis in its discussions and reports on global drug policy. Legal argument. As cannabis statutes moves toward nullification, the need for accurate terminology is more pressing than ever. To uphold the integrity of medical and legal history and practice, cannabis must be recognized and treated with the same respect as other medically accepted plants and substances that are grown at home. Capitalization of cannabis is a vital step in restoring its rightful place in medical science and legal practice. 6. Conclusion. Reclaiming cannabis as the proper name. It's clear from both historical records and legal documentation that cannabis has always been the proper scientific, medical, and legal name for our flowering plant. The decision to lowercase cannabis and elevate racially charged term marijuana was a deliberate act of linguistic manipulation, driven by an agenda to criminalize, stigmatize, and eradicate at all cost this flowering plant. Now, as cannabis freedom spreads and public opinion shifts, it is imperative that cannabis be treated with the respect and full freedoms for everyone equally as we deserve. The name cannabis should always be capitalized, reflecting its status as a proper noun, a term rooted in medical tradition, and a plant with profound historical and cultural significance. The scientific, medical, legal, household name. The record must be set straight, and we are now in the time where science and truth govern our understanding of cannabis, free from the shadows of information suppression, fraudulently perjured prohibition, and radical irrational racial prejudice. Chapter 11: The Endocannabinoid System, Historical Foundations, Nomenclature, and Legal Implications. 1. Introduction. The genesis and significance of the endocannabinoid system. The discovery of the endocannabinoid system, ECS, stands as a monumental achievement in modern medical science, elucidating the intricate interplay between endogenous compounds and specific receptors that regulate a myriad of physiological processes. This system's nomenclature is deeply rooted in its association with cannabis, a term that has been subjected to deliberate misrepresentation through governmental propaganda and terminological manipulation. Analysis of the X's discovery, its components such as
delta,
tetrahydrocannabinol, THC, and anandamide, and the etymological and legal ramifications of its naming, imperative of adhering to the scientifically and legally accurate term cannabis, highlighting the perjurious implications of substituting it with the colloquial and politically charged term marijuana. 2. Historical context, unveiling the endocannabinoid system. The journey toward understanding the ECS commenced with the isolation and identification of THC, the principal psychoactive constituent of cannabis, in the 1960s. This pivotal discovery ignited a series of investigations aimed at deciphering THC's mechanism of action within the human body. By the mid-1980s, groundbreaking research led to the identification of specific receptors responsive to cannabinoids, CB1 receptors predominantly located in the central nervous system, and subsequently, CB2 receptors, primarily associated with the peripheral nervous system and immune cells. The identification of these receptors substantiated the existence of a previously unrecognized endogenous signaling system, which was aptly termed the endocannabinoid system. 3. Etymology and nomenclature. The case for cannabis. The term endocannabinoid is a composite of endo, derived from the Greek endon, meaning within, and cannabinoid, which directly references cannabis. This nomenclature reflects the intrinsic relationship between endogenous compounds and the phytochemicals found in the cannabis plant. The utilization of cannabis in this context is not arbitrary, but is grounded in the plant's historical and scientific significance. Notably, the term marijuana is conspicuously absent from scientific discourse, underscoring its inappropriateness and lack of legitimacy in medical and legal contexts. 4. Anandamide, the bliss molecule. In 1992, researchers isolated anandamide, N-acetylphenolphenolamine, the first endogenous cannabinoid, from porcine brain tissue. The nomenclature anandamide is derived from the Sanskrit word ananda, meaning bliss, coupled with the amide chemical group, encapsulating its role in mood regulation and its structural characteristics. Anandamide's discovery illuminated the endogenous ligands that interact with cannabinoid receptors, providing profound insights into the X's functionality. 5. Legal and linguistic implications. Marijuana perjury of cannabis. The term marijuana lacks scientific provenance and has been historically employed in governmental propaganda to stigmatize cannabis and its users. This deliberate lexical choice constitutes a misrepresentation of factual information, amounting to felony perjury within legal frameworks. The capitalization of marijuana and the concurrent decapitalization of cannabis in legal documents were strategic maneuvers designed to diminish the plant's perceived legitimacy and therapeutic potential. Such terminological distortions have had enduring repercussions on public perception and policy, underscoring the necessity for precise and truthful language in legal and scientific discourse. 6. The imperative of accurate terminology in legal and scientific discourse. In legal and scientific contexts, the accurate representation of terminology is paramount. The term cannabis is the proper noun denoting the plant genus, and should be capitalized accordingly. Conversely, the term marijuana is a colloquialism devoid of scientific validity, and should be eschewed in formal discourse. The misapplication of these terms not only reflects linguistic inaccuracy, but also perpetuates misinformation, with tangible legal and societal consequences. Chapter 11, Part 2. The endocannabinoid system. ECS is named after its connection to cannabis and the compounds that were first discovered within this plant, which led scientists to identify similar molecules in the human body. Let's dive into the history and naming origins to clarify the role of THC and anandamide, and why it's called the endocannabinoid system. 1. Origins of the endocannabinoid system. The ECS was discovered in the 1980s and 1990s when researchers were studying how THC, the main psychoactive compound in cannabis, affects the brain. This led to the identification of receptors in the brain that responded to THC, specifically the CB1, and later CB2 receptors. Scientists initially named these cannabinoid receptors because THC, a cannabinoid from the cannabis plant, was the first compound known to activate them. As they continued studying these receptors, scientists found that the body produces its own molecules, or endogenous cannabinoids, often shortened to endocannabinoid, that naturally activate these same receptors. The term endocannabinoid combines endo from the Greek endon, meaning within, with cannabinoid referencing compounds in cannabis, to describe molecules in our body that engage with these receptors. 2. The role of anandamide and its classification. Anandamide, one of the first endocannabinoids discovered, plays a central role in the system. Named after Ananda, the Sanskrit word for bliss or joy, Anandamide binds to CB1 receptors, similarly to THC, producing mood-enhancing and pain-relieving effects. Although it's not derived from cannabis, anandamide is often considered a cannabinoid because it binds to the same cannabinoid receptors that THC does. 3. Why it's not called the endo-anandamide system. The ECS is named for its connection to cannabinoids, not specifically for anandamide, because cannabinoids, both from cannabis and endogenous ones, define the system's function. THC from the plant was the original key to discovering the receptors, and cannabinoids were the molecular class initially studied. Because the ECS includes other endogenous molecules, like 2-AG, beyond anandamide, that also engage cannabinoid receptors, naming it the endocannabinoid system makes it more inclusive of the broader category of molecules. 4. THC, anandamide, and cannabinoids. A comparison. THC and anandamide are both cannabinoids in the sense that they interact with ECS. However, THC is a phytocannabinoid plant-based, while anandamide is an endocannabinoid produced by our bodies. THC mimics the action of endocannabinoids, like anandamide, but often has stronger and longer-lasting effects, because it doesn't break down as quickly in the body. The etymology of cannabinoid and its influence on medical terminology. The term cannabinoid originated from the Latin cannabis, referring to the plant. When THC and other active compounds in cannabis were identified, the term cannabinoid was used to categorize these unique molecules. As scientists uncovered similar compounds within the human body, they adapted the term to define these naturally occurring molecules and as endocannabinoids. This connection to cannabis inspired the system's name, and has influenced how we understand ECS functions. In contrast, using the term marijuana in the U.S. English-speaking, legal lexicon, instead of the appropriate legal and medical terminology is and always has been government felony perjury, and is largely avoided by the informed majority because of illegal government propaganda, and the changing of terminology and definitions in the legal lexicon, not because of cultural and historical biases associated with that word, especially its origins and use in propaganda. If marijuana wasn't government felony perjury, then this biological system would be called the endomarijuana system. But it isn't called the endomarijuana system now, is it? Lastly, when you are doing your own legal history research on these subjects, pay attention to who is using what terminology, and in the literature, cannabis is a proper name for the plant. That means it should always be capitalized. That means it was capitalized before the perjury and propaganda. Pay attention of who started capitalizing marijuana and putting cannabis in all lower cases, and who never went along with the nefarious and transient unconstitutional and unlawful legal changes. All people have cannabis freedoms, and all people can call a thing whatever we want in a general context of understanding. However, it is blatantly illegal and criminal for governments and corporations to redefine terminology and definitions to suit their own nefarious, ignorant, and contaminated purposes. Recap: reaffirming the integrity of cannabis. Our consideration of the endocannabinoid system reveals a profound interconnection between endogenous physiological processes and the cannabis plant. The deliberate misnomer marijuana represents a historical artifact of misinformation and legal manipulation. It is incumbent upon the scientific and legal communities to rectify this terminological misrepresentation by reinstating cannabis as the accurate and rightful term. Such precision not only honors the integrity of scientific discovery, but also ensures clarity and honesty in legal and public discourse. Chapter 12: Cannabis and the Environment, Ecological Restoration, Bioremediation, and Green Future of Law. Cannabis is not merely a plant, it is a biospheric participant capable of catalyzing a needed paradigm shift in environmental restoration. Its potential to regenerate soil, sequester carbon, detoxify contaminants, and supplant petrochemical industries demands legal frameworks that not only permit, but incentivize, its deployment. Critical intersection of cannabis and ecological law, advocating for a jurisprudential revolution wherein the plant is no longer criminalized but exalted as a cornerstone of planetary rehabilitation. 1. Legal constraints on nature's remedy. A contradiction of constitutional stewardship. It's a profound irony that the very governments tasked with environmental stewardship have criminalized one of the most efficient, carbon-negative, and pollutant-cleansing plants on Earth. By outlawing cannabis, these institutions have committed a dual error: ecological malpractice and constitutional dereliction. The public trust doctrine, a principle rooted in American law, establishes that governments hold natural resources in trust for the public. Criminalizing cannabis, a plant that rehabilitates soil, reduces atmospheric carbon dioxide, and supports biodiversity, represents a breach of that fiduciary duty. 2. Cannabis soil regenerator and heavy metal absorber. Cannabis's phytoremediation capacities are well documented. In post-industrial sites and radiation-contaminated regions, such as Chernobyl, cannabis sativa has been deployed to extract cadmium, lead, mercury, and radioactive isotopes from the soil. The plant's fibrous roots uptake and immobilize these toxins, rendering the land arable once more. Legally reclassifying cannabis as an essential environmental tool, rather than a Schedule I narcotic, is imperative. Regulatory agencies such as the EPA and USDA must coordinate with Congress to codify cannabis's bioremedial role in federal environmental policy. 3. Carbon sequestration and atmospheric redemption. Unlike fossil fuel-derived industrial inputs, hemp grows rapidly, requires no synthetic fertilizers, and sequesters more carbon per acre than most trees. 1 hectare of industrial hemp can absorb up to 22 tons of CO2 annually. Furthermore, hemp-derived materials used in construction, textiles, and paper continue to store carbon for decades. This carbon capture utility necessitates recognition in climate legislation. Congressional climate packages, carbon credit markets, and the Green New Deal must enumerate cannabis as a climate-critical crop. 4. Water efficiency and agroecological compatibility. Compared to cotton and corn, cannabis requires significantly less water and grows without pesticide dependence. This renders it the ideal candidate for regenerative agriculture and permaculture systems. Its ability to restore nitrogen and organic matter to the soil through root biomass and leaf litter supports long-term agroecological health. Legal mechanisms such as the Farm Bill must be amended to distinguish between cannabis for environmental use and cannabis freedom classifications, removing non-scientific barriers to its agricultural proliferation. 5. Replacing petrochemical products and ending industrial pollution. From biodegradable plastics and construction materials to fuel and lubricants, cannabis offers renewable alternatives to petroleum-based products. Hempcrete, a mixture of hemp herds and lime, outperforms concrete in insulation, breathability, and carbon negativity. Legal regimes that currently subsidize petrochemical industries must be recalibrated to favor bio-based manufacturing. This requires dismantling the statutory and tariff structures that disadvantage cannabis relative to environmentally destructive industries. 6. The doctrine of ecological jurisprudence. Rewriting the legal lexicon, environmental law must evolve from anthropocentric exploitation and eradication to biocentric restoration. Ecological jurisprudence recognizes the rights of nature and obliges legal systems to treat ecosystems as legal subjects, rather than exploitable objects. Within this framework, cannabis must be declared a legal entity possessing environmental utility that cannot be preempted by outdated narcotic statutes. Just as rivers in New Zealand and Colombia have been granted legal personhood, cannabis, as a biospheric agent, must be endowed with legal recognition in environmental litigation and climate policy. 7. International law, climate agreements, and cannabis inclusion. The Paris Climate Agreement and the United Nations Framework Convention on Climate Change, UNFCCC, must be interpreted expansively to permit cannabis cultivation as a carbon sequestration and mitigation mechanism. The continued exclusion of cannabis from climate protocols is legally incoherent and environmentally negligent. Nations must push for amendments that reflect the plant's critical role in meeting emission reduction targets. 8. Policy recommendations. Legislative pathways to environmental emancipation. Remove cannabis from all narcotics schedules and reclassify it under environmental and agricultural codes. Incorporate cannabis cultivation into federal and state climate change mitigation strategies. Extend crop insurance and agricultural subsidies to environmental use cannabis growers. Establish environmental cannabis research institutes with federal funding. Amend the Clean Water Act and Clean Air Act to allow bioremediation using cannabis. Classify hempcrete and bioplastics under green construction tax credits. 9. Conclusion. From prohibition to preservation. To continue criminalizing cannabis via legalization in the face of ecological collapse is both scientific absurdity and a legal betrayal. The green future of law must be one in which cannabis is not merely permitted, but protected, enshrined as a keystone species in our legal ecosystem. Jurisprudence must transcend fear-based statutes and embrace regenerative logic. Environmental justice demands it. Scientific integrity necessitates it. The survival of life on Earth depends on it. Please feel free to read my other book, Modern Legal Etymology and Nomenclature of Cannabis, Marijuana, and Marijuana, https://docs.google.com/document/d/1n8CWWZGSK BK5H1IX1WB41 tap DE4Z_6R/FUCK-VSI-PZ5/edit. F. Patronize my honest efforts and prolonged dedication at https://www.paypal.me Isaiah-Alleman. Thank you all. Unanimous Declaration of Independence in Congress, July 4, 1776. The unanimous declaration of the 13 United States of America, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shown that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty, to throw off such government, and to provide new guards for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. He has refused his assent to laws, the most wholesome and necessary for the public good. He has forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained, and when so suspended, he has utterly neglected to attend to them. He has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records, for the sole purpose of fatiguing them into compliance with his measures. He has dissolved representative houses repeatedly, for opposing with manly firmness his invasions on the rights of the people. He has refused for a long time, after such dissolutions, to cause others to be elected, whereby the legislative powers, incapable of annihilation, have returned to the people at large for their exercise, the state remaining in the meantime exposed to all the dangers of invasion from without, and convulsions within. He has endeavored to prevent the population of these states, for that purpose obstructing the laws for naturalization of foreigners, refusing to pass others to encourage their migrations hither, and raising the conditions of new appropriations of lands. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone for the tenure of their offices, and the amount and payment of their salaries. He has erected a multitude of new offices, and sent hither swarms of officers to harass our people, and eat out their substance. He has kept among us, in times of peace, standing armies without the consent of our legislatures. He has affected to render the military independent of and superior to the civil power. He has combined with others to subject us to a jurisdiction foreign to our constitution, and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for quartering large bodies of armed troops among us, for protecting them, by a mock trial from punishment for any murders which they should commit on the inhabitants of these states, for cutting off our trade with all parts of the world, for imposing taxes on us without our consent, for depriving us in many cases of the benefit of trial by jury, for transporting us beyond seas to be tried for pretended offenses, for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments, for suspending our own legislatures, and declaring themselves invested with power to legislate for us in all cases whatsoever. He has abdicated government here, by declaring us out of his protection, and waging war against us. He has plundered our seas, ravaged our coasts, burnt our towns, and destroyed the lives of our people. He is at this time transporting large armies of foreign mercenaries to complete the works of death, desolation, and tyranny, already begun with circumstances of cruelty and perfidy scarcely paralleled in the most barbarous ages, and totally unworthy the head of a civilized nation, he has constrained our fellow citizens taken captive on the high seas to bear arms against their country, to become the executioners of their friends and brethren, or to fall themselves by their hands. He has excited domestic insurrections amongst us, and has endeavored to bring on the inhabitants of our frontiers, the merciless Indian savages whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. In every stage of these oppressions we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince, whose character is thus marked by every act which may define a tyrant, is unfit to be the ruler of a free people. Nor have we been wanting in attentions to our British brethren. We have warned them from time to time of attempts by their legislature to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our emigration and settlement here. We have appealed to their native justice and magnanimity, and we have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They too have been deaf to the voice of justice and of consanguinity. We must, therefore, acquiesce in the necessity, which denounces our separation, and hold them, as we hold the rest of mankind, enemies in war, in peace friends. We, therefore, the representatives of the United States of America, in General Congress, assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name, and by authority of the good people of these colonies, solemnly publish and declare, that these united colonies are, and of right ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. New Hampshire: Josiah Bartlett, William Whipple, Matthew Thornton. Massachusetts: John Hancock, Samuel Adams, John Adams, Robert Treat Paine, Elbridge Gerry. Rhode Island: Stephen Hopkins, William Ellery. Connecticut: Roger Sherman, Samuel Huntington, William Williams, Oliver Walcott. New York: William Floyd, Philip Livingston, Francis Lewis, Lewis Morris. New Jersey: Richard Stockton, John Witherspoon, Francis Hopkinson, John Hart, Abraham Clark. Pennsylvania: Robert Morris, Benjamin Rush, Benjamin Franklin, John Morton, George Clymer, James Smith, George Taylor, James Wilson, George Ross. Delaware: Caesar Rodney, George Reed, Thomas McKean. Maryland: Samuel Chase, William Paca, Thomas Stone, Charles Carroll of Carrollton. Virginia: George Wythe, Richard Henry Lee, Thomas Jefferson, Benjamin Harrison, Thomas Nelson, Jr., Francis Lightfoot Lee. Carter Braxton. North Carolina: William Hooper, Joseph Hughes, John Penn. South Carolina: Edward Rutledge, Thomas Hayward, Jr., Thomas Lynch, Jr., Arthur Middleton. Georgia: Button Gwinnett, Lyman Hall, George Walton. FFF. Flyleaf. Back cover. Things to keep in mind when reading this book: how easy it is to make people believe a lie, and how hard it is to undo that work again. The more erroneous is his judgment, the greater is the tenacity with which he holds it. It is easier to bamboozle than to debamboozle. Samuel Langhorne Clemens. Pen name: Mark Twain. Samuel Clemens never said it's easier to fool someone than to convince them they have been fooled. Most people believe they haven't been fooled. This doesn't mean that most people can't and don't believe lies they have been told. P.S. WIP. One of the challenges in producing this book is that the tools and resources that I've used to create it are confused because of the terminology and definition changes. Check and verify everything for yourself before immediately believing what any given situation may or may not be. It's not entirely ready for publication release. Still, I'm putting it out there because it's probably the best we have available, even though it needs a lot of work.